May I please, Your Lordship? Yes. My Lord, I beg to mention item number 10. My Lord, here I'm yet to receive instruction. So kindly allow me 2 weeks time.
Item 10 at the request of
E.T. Home, government.
the government advocate.
Yes, ma'am.
Matter stands adjourned to be listed after
2 weeks.
2 weeks. Any objections? Prayer made is not objected to by counsel for the petition. Yes.
Much obliged. May I please, Your Lordship? My Lord, I beg to mention item number 7. 11 and supplementary from cost, supplementary cost list, item number 24.
Item 7,
11
11 and
and 24, my Lord.
24.
I have not received any instruction, so let this matter will come up.
11 and 24 is the heaviest matters. If Lordship can kindly show some indulgence and take up the matter.
We can take it up, but let the matter be called up then. Let it be called up. Let the matters be called up. Will you renew your prayer when the
My
matter
lord.
is called up?
My Lord.
Yes.
May I, please, my lord, hearing item number 20, Lordship.
20.
Lordship may be listed after 2 weeks, Lordship. I've taken the consent of that,
You're for the appellant.
Lordship.
Appeal preferred by the appellant, counsel. Counsel for the appellant prays for adjournment for 2 weeks. Prayer made is not objected to by the counsel for the respondent. List accordingly after 2 weeks.
Lordship. And Lordship, item number 23, here also I've taken the consent. The other party may be listed after 3 weeks, Lordship.
Item 23, same prayer,
3
same
weeks.
order, same order.
Lordship, 3
After
weeks.
3 weeks.
Yes.
All right, after 3 weeks.
Mr. Lordship, Lordship, I beg to mention item 22 on behalf of additional AG, Ms. V. Sokrit. I pray that the matter may be listed after 2 weeks.
22.
Your Lordship, if it is gone, may I pray for fixing a date, Your Lordship? It's a matter will be fixed on 27/11, Your Lordship.
27/11.
Your Lordship, because that would be day after, Your Lordship, Justice Manor, the Lordship should be sitting, he cannot take up
All right. 27.
on 27/11.
Prayer is made on behalf of the respondents seeking an adjournment. Counsel, stop counsel for the appellant submits that the matter be listed on a fixed date. Stop accordingly as agreed to by counsels for the parties. Matter be listed for hearing on 27/11.
Of Lordship.
Lordship, I also like to mention item 4 on behalf of additional AG, Ms. V. Sokrit.
Item 4.
Yes.
My lord, I'm for the petitioner. If it is not today, 2 weeks, in that case, may I pray that let it be released on 27, division bench 27.
27th.
My lord.
Item 4, at the request of made by the government advocate, matter stands deferred to be listed on 27/11. Mr. Azo appears for the petition.
And my lord, there's an interim order then.
Interim order passed earlier will continue.
Much of that.
Obliged, Your Lordship.
May I please, Lordship. Lordship, I beg to mention hearing item number 21,
21.
Lordship. Making on behalf of the counsel for the appellant, Y.B. Gupta. Lordship, he is a heart patient, Your Lordship, and so he is out of station for his medical checkup. But this matter may come up next week, Your Lordship, 20.
Yes, any objection?
Lordship, here for respondent number 2, the principal accountant general is made a party, Lordship. In the earlier writ proceeding, our name has been deleted because we are not a necessary party in this case. However, in the appeal again, we have been made a party again.
You make a mention on the next date, you renew your prayer.
Fine.
Item 21.
Lordship.
At the request of the counsel for the appellant, matter stands deferred to be listed after 2 weeks.
Next week, Your Lordship, date 20.
Praise accommodation for this week. Is agreed to, let the matter be listed again on which date?
20,
20.
Lordship.
Oblige your lordship.
Oblige, my lord.
May please lordship, please allow me to mention hearing item 19. I've taken the consent of the appellant counsel. On behalf of our liaison, the leading counsel for the respondent. The matter may be fixed after 3 weeks.
Prayer is made on behalf of the respondent of the respondent. It is submitted that consent of the counsel for the appellant is obtained. Learned counsel for the respondent prays for
For 3 weeks.
3 weeks' time. Prayer, since there is no objection from the appellants, matter be listed after 3 weeks.
Highly obliged.
Yes, yes, yes.
For admission, item number 1.
Some affidavit has been filed.
Yes, lordship.
Yes. Have you seen that copy?
Lordship,
Yes, I just received, Lordship.
Yes, you see.
Yes.
In fact, the officer concerned was on a training, so we could file it only yesterday, lordship. So as per the direction of this honorable court, lordship, as per the last order,
This is, well,
yes, lordship.
yes. So you go through the affidavit and tell us if there's something more required.
Okay, Lordship, as per, I believe this is filed as per the submission made on the last occasion regarding the completion of 4 blood banks in 4 districts, Lordship. So more or less, few of my prayers with this, it has been, the issue raised in the petition are answered, few of them, Lordship. So if the Lordship agree, please, then this matter can be closed with few directions, Lordship. This petition was filed in the year 2021. And over the years, Lordship, there has been a lot of progress have been made. One of the concern was the non-functional of blood component separator, which is there in Naga Hospital Authority, Kohima. So that is also in the process of hearing, Lordship, that is also been addressed. And also, yes, I had special prayers. We had special prayers for setting up of blood banks in the district hospital in Parent, Kifiri, Longland, and also in Noklak district, which is, it is a district, but it's still yet to be upgraded. So its function is community health centers, Lordship. So as per the guideline of the national guideline, every district is supposed to have a blood bank because it is a requirement, Lordship. So as far as during the pendency of this petition, before this petition was filed, we have also filed an RTI, and then we learned that only 8 districts in Nagaland have blood banks, Lordship. So with the addition of 4 more, it will make it 12. So that means now we have 17 districts in the state. So if an endeavor is made, Lordship, to have it set up in all the districts in the long run, Lordship.
That endeavor has to come from you. You're the petitioner, PIL petitioner.
Yes, Lordship.
So why do you want to close it?
Lordship, then in that case, if direction may be issued so that,
We can issue a direction.
Lordship, yes.
This is not a suo motu, is it?
It is not, Lordship, it is not. And also, I have one very sincere prayer that has been raised in this petition, Lordship, that the eastern area of Nagaland has been neglected. So one of my prayers is that to address, to bridge the plethora of gaps in infrastructure development, a prayer was made. If one
Infrastructure with regard to what?
healthcare, Lordship. So if one blood component separator can be set up in one of those districts.
So, lordship, as a matter of procedure, lordship, first, the district hospital should have a blood bank. We have to go through a series of checking, lordship, whether we have the facility. Then comes the blood component separator, lordship. So we have to go stepwise. No, lordship.
Why don't you file a comprehensive affidavit?
No, lordship, we have already filed, lordship, to that effect. Yes.
Indicating what is the status of these blood banks in all the districts. You have set up-
Lordship, the prayer of the petitioner in the instant PIL is specific, Lordship, specific.
Ipre, Longjen and Noklak.
Noklak, yes. That's three are in the eastern area, Lordship.
Right.
So we have already set up
You have set up,
the blood bank, Lordship. Now we have to go through the process of getting the license from the licensing authority, central licensing authority, Lordship. And through the initiative of NESIT, under NESIT, Government of India, Lordship, this blood bank was allocated to the state of Nagaland during the COVID time, Lordship. So specifically, we have stated in our affidavit, Lordship, as per the direction of this Honorable Court, Lordship, in compliance and as per the commitment given by the government, Lordship.
no, in your affidavit, you have highlighted only 4 districts.
4 districts, Lordship.
Suengsang, Kipre.
Those are the 4 new districts which have been earmarked, Lordship.
But the prayers here are with respect to, okay, Kipre is taken care of, Longlang, Noklak
Yes, Lordship.
and Peren.
Lordship.
So what steps have you taken? Is there any affidavit available here?
Kifri Longland has been complied with, Lordship.
What is the status in the districts?
Lordship.
Since this is a PIL, we did not restrict ourselves to only the prayers made.
Lordship.
So you can file a detailed affidavit to show what is the status of the blood bank in all the district hospitals, in all the districts.
Lordship. Lordship, and as a matter of procedure, to have a blood bank in a district hospital, there should be a consumption of 2,000 units per annum. Lordship, we are bound by the guideline of the Government of India. If there is no consumption of 2,000 units in a year, we will not get license, Lordship.
Place that by way of an affidavit. Because
We can do that, Lordship,
because
yes.
the prayer here is to issue orders and directions for setting up of blood banks in all district hospitals. This is the prayer in the PIL.
You,
Practically, Lordship, practically, it will not be possible to have blood bank in all the district hospital because the consumption, that is one of the requirement, Lordship.
that's what you place it before the court and you tell us that as per the record.
Yes, Lordship. Yes,
So
I
far
can
as-
do that. I can do
as far
that,
as
Lordship.
this district is concerned, this is the consumption, therefore not feasible.
Yes.
Yes, Lordship.
You place it before the court, we will
Yes,
consider.
definitely, definitely. I'll do that, Lordship. Because to have a blood bank in all the districts, it's practically,
Say that in your affidavit.
yes, I can do that, Lordship.
But not to have is also surprising.
Yes, Lordship.
2,000 units may not be consumed. What about 1 unit for somebody? It may
Yes.
be a matter of life and death.
Yes, Lordship. No, Lordship, to that extent, we can have blood storage.
So you suggest
Yes.
that instead
But
of,
the petitioner, they're asking for blood bank.
this is not an inter-party litigation. This is a
Lordship,
public
Lordship,
interest litigation.
Lordship.
It's not just in the interest of the litigant.
Lordship.
So therefore, we cannot be so restricted in the
Prayers.
prayers or contentions.
Yes, Lordship.
So the concept is that whether the people are getting
Yes,
sufficient medical assistance.
Lordships.
At least in terms of blood storage, blood banks, etc.
Lordships.
So
Lordships. If enough time may be given, granted to me, Lordship, so that I can bring that to the record of the court, Lordship.
Yes.
Why it's not feasible to have blood bank in all the
The
districts?
alternative that you are suggesting.
Yes, Lordship, we can do that, Lordship.
we are asking you to examine.
Lordship,
But it appears that you have already concluded that it's not feasible.
Lordship.
Whatever it may be, you bring it on record.
The alternatives, Lordship, yes.
Yes.
Definitely, Lordship. I'll do that, Lordship.
Third, MS so-and-so, learned counsel appearing for the PIL petitioner. Mr. Muzoi, learned standing counsel for the health.
Respondent number 1, 2, and 3 and 4.
What is that? Health or NHM?
NHM, the medical department, Lordship. I'm presenting the
NHM.
Health and Family Welfare Department,
Health and Family Welfare.
Lordships.
This is the respondent number 1, 2,
3 and 4,
3 and 4,
Lordships.
not 5.
No,
I am paying for 5. I have already filed my affidavit.
Then it's CGC appears for 5 and 6.
The 5 and 6.
Pursuant to the court's order, earlier order of the court. An affidavit has been filed by the
1, 2, 3,
mission
and 4.
director,
Lordship,
NHL,
Lordship.
on behalf of respondents 1, 2, 3, and 4. To bring on record the steps taken for setting up of blood bank equipments in the 4 districts of Chuengsang, Chipre, Mon, and Phek.
Lordships.
Perusal of the affidavit reflects that the work orders have been issued to the vendor and the various machineries required for installation of blood banks have been stated to have been supplied. The documents enclosed to the affidavit reflects that the machinery has been received
Lordships.
and demonstration report as well as the installation report
Lordships.
are enclosed to show that the machinery installed in these districts are working as per the required standard. So. The perusal of the prayers made in the PIL reflects that there's a prayer, specific prayer in the PIL, particularly prayer number G, to issue orders and directions to the respondents to improve hospital infrastructures in District Hospital Peren, Kipre, Longlen, and Noklak for storing blood. Stop. Since this is a public interest litigation filed and the issue raised is of substantial importance to the citizens, more particularly those residing in rural areas and not having access to adequate and sufficient health, sufficient medical and health medical and health necessities by way of hospitals and other ancillary facilities offered in those hospitals, including access to blood banks and blood storage units. This court is of the view that a direction be issued to the respondent number 2, 1, 2, 3, and 4.
Lordships.
To file a detailed affidavit to place before the court the status of existence or the availability of blood banks as well as blood storage units in all the 17
districts.
17 districts of the state of Nagaland. Stop. Depending on the materials which are placed before the court by way of the affidavit as directed, further orders as necessary, as far as deemed necessary, may be passed by the court.
Lordships.
The respondents are granted 4 weeks' time
Lordships.
to file the detailed affidavit and apprise the court accordingly. Matter be listed after 4
Worship,
weeks.
if I may have allowed. Let the name of the respondent number 6 be deleted from the, because we have that what the Union of India,
Who's respondent 6?
the Union of India, Ministry of Health and Family Welfare.
So
Because
why-
we are not,
why-
because we are not a necessary party here, we have already given whatever has been given. Financially, we
Has
have
any directions been issued to respondent 6 as yet?
no, nothing,
Then
because
why
we are just a
why
performer
are you
respondent.
apprehending?
We're just a performer resident. We have already
You remain. You are the nodal ministry of the government of India.
my lord.
How can you not be a necessary party? You be there.
Because this is a health issue, it's a state matter, lordship. It is not,
We'll look into it. On the next day, we'll consider your prayer if required. Let all these materials come from, let us see what steps have been taken for installation of all these blood banks, etc. Okay. Placed again on a date to be fixed by the registry after 4 weeks.
lordships, 4 weeks.
Obliged lordships.
4 weeks. Oblige, your lordship.
For admission, item number 2.
Yes.
What we have filed an affidavit on 8/11/2024 in compliance of this honorable court's order, lordship.
If I may, my lords,
Yes.
the affidavit has been filed and the steps contemplated they are mentioned in paragraphs 2 to 6. In paragraphs 2 to 6.
We are yet to find the affidavit. Some affidavit. When was it filed? Yesterday.
8/11, lordship.
8/11.
Lordship.
This is filed by?
NHIDCL lodge.
Respondents 2 and 8.
288.
All right. What do you say here?
Lordship, the steps to be taken, lordship. We have received a direction from the ministry, lordship, to evaluate and submit a proposal, lordship.
Yes, Mr. Zimobi, what do you say?
My lord, the steps are mentioned in paragraphs 2 to 8. The step seems positive, but what is mentioned in these paragraphs indicates a time-consuming process, my lords. Now, the point of concern is this: we are now in the working season, and rains with climate change, your lordships, it may happen anytime from March, end of March, April, May. So these are precious months. So the respondents 1, 2, and 8, they must think of ways to fast track the process, my lords. Otherwise, the steps contemplated in paragraphs 2 to 6 indicate a time-consuming process.
Yes.
Lordship, we have
Where
to,
are your representatives? We directed on the last day that they should be present. Where are they?
lordship, it is in regard to a different PIL, lordship.
Oh, it's a different.
Yes,
PIL,
lordship.
sorry. I'm getting confused. So many
Lordship.
PILs.
It's related to Kohima
Highways.
Dimapur, lordship.
Yes. That's regarding a different PIL.
Yes, lordship, Kohima Dimapur highway.
This is which highway?
Kohima to Mao Gate, lordship.
I thought it was Kohima Dimapur, which is why the amicus is not in physical appearance before the court. It was so bad that he has to take help of VC. All right. The amicus has, raised a point of concern. because
Yes, lordship.
Then,
Lordship.
then you
Yes,
have to
lordship.
take up your proper steps.
Lordship. We have stated in our affidavit, lordship, that a direction was issued by the ministry to evaluate the balance work, lordship, and to submit a proposal, lordship, which we have.
National highways are all taken over by National Highway Authority.
Not all, lordship, but a few projects in the state of Nagaland, lordship. Yes.
I think the BRO has a better performance report because they are building all the connecting roads in the interiors. I don't know why National Highway is not able to do it. If National Highway is not able to do it, who will?
Lordship, there are some certain projects which we have completed on time, lordship, and it has been handed over,
So
lordship.
why don't you complete this on time?
Lordship, because of the circumstances which we have.
You find out some other means to expedite this.
Yes,
Because across Northeast, after April, hardly any work can be done.
yes, lordship, I agree that, lordship.
Then-
Lordship, on the previous occasion, we have filed an affidavit,
So if you, even if you issue a tender,
lordship,
the rates which are offered by the contractor
lordship,
will keep on changing after April because they'll not be able to work.
lordship. Now, what has happened was, lordship, I have also enclosed the LOIs that has been issued to two contractors, lordship, for short-term maintenance, which will complete by this month, and they will maintain the defect liability period for 6 months, Lordship. They will maintain till such time, Lordship, we complete this process of tender. And this balance work, Lordship, it may take nearly 2 months, Lordship, because we have to evaluate we have instructed the authority engineer to evaluate and submit the proposal, Lordship. Once the proposal is submitted, we'll forward it to the ministry, Lordship. And the tenders will be floated, Lordship, accordingly.
No, you do one thing. You have indicated the steps you want to take, but you
Lordship.
have not indicated the time factor.
Lordship,
You indicate in an affidavit the time for each of the steps.
Lordship.
You should have done it in this
I have
affidavit.
verbal instruction, Lordship. It may take nearly 2 months, Lordship.
Whatever it may be. See, come to para 2.
Lordship.
Regional office so-and-so instructing to evaluate and prepare documents.
Yes, Lordship.
How much time would be required? Nothing.
total,
Authority
Lordship.
engineer has been directed to conduct detailed and careful assessment. Evaluation involves on-site verification, etc. Detailed report with regard to balance will then be submitted when?
Lordship.
Whether your engineer has been deputed, what steps has he taken?
Engineer is on the field, Lordship. There is an authority engineer appointed by the NHIDCL, Lordship. He's on the field. And we have already instructed the engineer to evaluate and submit a proposal, Lordship.
So you are saying that step 3 has been initiated now,
Lordship.
paragraph 3.
Yes, Lordship. Yes, Lordship.
And then how much time is it going to take?
Till the NIT is floated, Lordship, it may take nearly 2 months, Lordship.
No. NIT can be floated only upon your engineer
Yes,
costly
Lordship.
assessment.
Yes, Lordship.
So how
So
much time
in
is it
total,
going to take?
Lordship, 2 months time.
2 months time.
Yes, Lordship.
Yes, Mr. Zimobi, he says 2 months time.
Well, that's all in-house procedure, my lord. What I'm suggesting is that the NHIDCL and the MORTH respondents 1, 2, and 8 sit down together and fast-track the process. Otherwise, precious months will lapse, your lordships.
We'll make an interview, Lordship. We'll make an interview to expedite it, Lordship.
It heard. Micus as well as Mr. Consol, learned counsel appearing for NHIDCL.
Lordship, 1, 2, and 8, Lordship.
1 to 8. Pursuant to the earlier order of the court.
May I please, Your Lordship?
Yes.
My lord, I'm appearing on behalf of my senior for respondent number 9. I have appeared to remove our name from the case since the contract is already been terminated.
Let the report of the engineer come first.
Yes, Lordship.
After that, we'll take a call. Yes, anyone
Lordship,
else?
for the respondent number 10, the authority is engineer.
The authority engineer.
Yes, Lordship.
Which authority?
The
The person mentioned in paragraph 3, my lord.
Okay, so you
So
are,
if a specific query can be put to the authority engineer, how much time will it take to prepare the report?
yes,
Lordship, I'll take instructions and then file appropriate affidavit by next Tuesday.
by next Tuesday,
Yes, Lordship. That is 19th.
right?
Wednesday, next division bench will sit on 20.
Find out if you can find out petition, I don't know, is responsible. All right, learned counsel appearing for NHIDCL has submitted that an affidavit dated 8 November 2024 has been filed pursuant to the orders of the court. In terms of the as per in the affidavit, the various steps proposed to be undertaken by the NHIDCL for completion of the balance work has been indicated. Stop. A perusal of the affidavit reveals that in the absence of the specific time frame necessary for each of these steps to be undertaken, it is not possible to gather the period that may be necessary for completion of the balance work. Stop. Learned amicus has pointed out that the working season in the state of Nagaland and larger and greater parts of the Northeast are during the winter months, and which slowly ceases after the month of April when the rains start. Stop. In the face of the submissions made by the amicus before the court, this court considers it appropriate to direct the respondents. Respondents, you are respondent number?
128, and the authority engineers can.
Where is the petition, PIL petition? Right.
Respondent one is the Union of India Ministry of Road Transport and Highways, Your Lordship.
We are grappling to find out the course title, it's not here. Anyway, the respondents NHIDCL and its where do we find it?
It will be
In one of the orders, Your Lordship, the full array of parties is there in any of the orders. If we have a typed copy.
Yeah. All right, we find it. Respondents number. This is one, and then what happens? Okay. Respondent number 2. Then. Is the PWD also involved?
No,
Is the PWD not involved?
not involved, my lords.
All right, respondent number 2. Respondent number 10. Who is respondent 10? Authority engineer?
Yes, I'm representing respondent number 10, Lord.
You are rendering services for which company?
Lordship, I am overseeing the work
No,
that
are
is
you
being
an
executed
employee
by
of
the
the-
contractor.
Are you an employee of the NSCL, NHIDCL? No.
What should we have appointed
Yes.
the authority?
No, Your Lordship, the authority engineer is an agency of the NHIDCL appointed to oversee the work of the contractor.
So I'm to oversee the work of the respondent number 9, Lordship. But the respondent number 9 contract has been terminated at the moment.
All right. Then respondent number 8. Respondent number 10. Will file a consolidated affidavit.
Even the respondent number 1, my lords.
Respondent 1 is the union.
Yes, my lord, MRTH.
All right, respondent 1 also will file a consolidated affidavit indicating the time frame for undertaking and completion of each of the steps as mentioned in paragraphs 2 to paragraph
2 to 6.
6. In
2 to
the
6, my lord.
in the affidavit of compliance filed on 8 November 2024 by the General Manager Projects NHIDCL PMU Jakhama. Let this affidavit be filed within 2 weeks from today. Further orders thereon will be passed upon the affidavit as directed is filed. Stop. MS so-and-so learned counsel appearing for respondent 9
Yes, Lordship.
submits that respondent 9 was the contractor who was earlier awarded the contract and whose contract has in the meantime been terminated, and therefore respondent 9's name be deleted as it is not a necessary party before the court. Stop. The prayer made on behalf of respondent 9 will be considered by the court upon upon the affidavit as directed above is filed by the concerned respondents. List accordingly after 2 weeks. On a date to be fixed by the registry.
Much obliged, Your Honors.
For admission, item number 3.
So what news?
Not positive, Lord.
Not positive.
Yes. On the last occasion, that is on 6th, when the matter was taken up, submission was made by the counsel for the petitioner, the respondent, that the review application is due for listing on 8th. That is 2 days after that day. And then it was thought that some order may be passed on that date. But then it is learned that the matter has been deferred to 19th without passing any effective order. Now, Lordship, considering the concern expressed by your Lordships on the last occasion with regard to the taking up the matter and all that, as far as possible, I have also done some research to a great extent. And I tried to find from the Supreme Court, but there is no judgment of the Supreme Court. But there is one case, a full bench judgment of the Allahabad High Court. There, the issue was subsequent to the filing of the review application, a writ appeal was filed. And the controversy was whether by virtue of filing the writ appeal, the review will be incompetent to proceed. Now, the answer was given in negative, and in substance, the judgment was that both review as well as appeal can proceed. But considering the nature of the case, for example, in the review, if any order is passed, reversing the order or the decree, then in that case, the order will go. Now, so far as the present case is concerned, the review application which has been filed by the 2 applicants, the prayer is very limited to the extent of the 2 petitioners, 2 applicants of the review in the review. So if it is allowed, if review application is allowed, the grievance of the petitioners will remain the same. If it is dismissed, review application is dismissed, the grievance of the petitioners will remain the same. Therefore, it will be of no consequence because in the review, the prayer is limited only in respect of the 2 applicants in the review application.
Let me understand
Lordship.
the parameters, the contours of this appeal. Before the writ court, what was the finding of the writ court in dismissing your, in allowing the writ petition, interfering?
The recruitment was done without advertisement. That is one.
That finding, was it arrived on the basis of examination of all these documents? As far as subject to correction, there was a statement, there was a submission on the part of the government to say that both are similarly situated. Its writ petition has already been answered. It is stands covered.
Correct, Lord.
Is that the only?
That was one of the grounds. And with regard to the advertisement, the other case was with regard to the constables.
No, we'll go to that. Insofar as your case.
Yes.
The writ petition was allowed.
Yes.
On the ground that it stands on the same footing.
Yes.
As the case pertaining to the constable.
Correct, Lord.
And constable's case has already been answered.
Yes.
Which submission was not disputed by the respondents and perhaps by the petitioner also.
Lordship, a pointed query was made to the learned Advocate General and the counsel representing the petitioner and the state respondents.
Or everyone agreed?
That query was not put to the council for the present appellants. But
That those two appellants were before the review. Are you saying that?
no. We were all implemented as respondents jointly. So had any affidavit been filed in the writ petition
By?
by the present appellants,
Okay.
who were the respondent in that case,
Right.
private respondents, the outcome would have been different because all these things can be could have been projected. But this has not been projected. Why? No affidavit was filed. That is why the serious communication gap was there between the client and the council. And the client has given the instructions, but in view of the communication gap, no affidavit could be filed by the private respondents. Had any affidavit has been filed, this problem could have been solved already that look, these two persons are selected through a regular selection process, proper selection process. Therefore, their appointment should not be interfered with. That is one. Another very important point, which is very, very vital, is with regard to the recruitment of the constables. Rule 20 was referred to, and then a notification was referred to, that is notification dated 7/7/1976, which says that any appointment in the government service should be through advertisement. So far as police department is concerned, in 2004, the state government has issued a notification exempting the police department and conferring the power to the Director General of Police to make appointment in the exigencies of service, the sub-inspectors, and there is no recruitment rules except the Nagaland Police Manual. So taking power from the Nagaland Police Manual, these appointments were made, and all those points were not projected before the learned single judge when constable's case were also heard, and in the present case where the judgment has been imbued.
You are well aware of those line of decisions that what is the position in the intra-court appeal?
Lordship, just a minute, Lordship.
Right.
The bone of contention of the petitioner was two. Number one, it is a backdoor appointment and illegal appointment. That was the sole contention, and the recruitment has been done without advertisement.
No, without going into the merits.
Lordship.
I am interrupting.
Lordship.
Only to understand
Lordship.
whether we should proceed in the matter or not. The query that is going on in the mind of the board, that this is an intra-court appeal.
Yes.
You are challenging the order of the single judge.
Yes.
On what ground? That this writ petition was disposed of as being covered by a coordinate bench.
Yes.
Order.
Yes.
When it is not.
Yes.
There are certain aspects which ought to have been brought before the court, it was not brought.
Correct.
Therefore, and the councils agreed. Therefore, the court proceeded that yes, it is covered and disposed of the matter.
Lordship.
So therefore, essentially it becomes a consent order.
Lordship, in that I have one answer, one reply, Lordship. For the lapses on the part of the council.
We are not even going into that aspect. What we want to know is, what are we supposed to now decide?
Yes. So
What are we supposed to decide?
I will just refer to only two paragraphs. By reading these two paragraphs, thereafter I leave it to your Lordship to take a decision whether to take up or not to take up. Bihari Lal and another versus M. Govardhan Lal. I believe Lordships are aware of this judgment.
No, point out from the judgment in appeal that what are we to decide? If we accept whatever you are submitting, number one, there was no counter affidavit, etc. filed before the coordinate bench, before the single judge. Whatever materials comes here now is a fresh material, which was never before the single judge. So, prima facie view is that perhaps this is a matter which is required to be confronted before the single judge by way of filing a review.
Most appropriate.
Because your challenge to the order is the intra-court appeal, we may not interfere merely because there's a point of law. it must be an order which is contrary to the express provision of
That is
law.
why, Lordship, the most appropriate
purpose.
order should be to remand the matter to the learned single judge, and the learned single judge hear the entire matter, in which case, consequently, the review petition will be automatically solved. Nobody is disputing that these two persons were not selected through proper selection
We would have-
process.
We would have done that had that review petition not been filed. That review petition was filed. Notices were issued. It is pending now.
That is why,
By-
Lordship,
By assuming we accept your submission for remanding, as you have rightly pointed out, the review petition will become redundant.
now, Lordship, I'm putting a question. Whether this honorable court can go beyond the relief sought for in the application, in the writ petition or in the case of review. If in the review application, the answer is, if it is no, this court cannot go beyond the prayer sought for in the application. Then in that case, the prayer made in the review application is in respect of two persons only.
No, like I said earlier, supposing the single judge feels that yes, the review has to be answered. We cannot predict what kind of orders will come from the single judge. But perhaps it may require a rehearing of the matter to some extent. If that rehearing is done, then the judgment will have to be recalled.
But the prayer sought in the review application is only in respect of two persons.
Right. That's right. But if two persons, if the court is of the view that yes, it was not correctly decided, then the court is required to decide the. We can't say exactly how the court will take up the matter, but ordinarily, as a matter of practice, if you find errors in the judgment, you recall the judgment, whether it is for 2 or for 5 or for 10. And then hear the matter. So that was the only
To
reason.
do that.
That was the only reason we thought it prudent to defer it. But then you say it is fixed on
19.
Lordship.
19th.
Yes, Lordship.
Why not have it on 20?
Lordship.
Yes,
Have this matter on 20.
Lordship, yes. But
You see, as a council, you can make any kind of submissions. But as the court, we must maintain that judicial discipline. If we pass an order remanding, assuming we are convinced that yes, it requires a rehearing, we remand it. The review filed by a person.
that is the reason why, Lordships, I want to refer to these two
All
paragraphs
right, we'll go.
in the judgment.
We'll go.
Only two paragraphs.
Yes.
And then Lordship can decide. 10 and 12.
10 and 12. Paragraph 10 and 12.
The one which is placed before Lordship is without any paragraph
Without any paragraph.
from the SSC.
You can tell us the page numbers.
Paragraph 535 in your Lordship's copy.
Yes, yes.
The paragraph starts with, it is true that. Order 47.
Yes,
That's your Lordship got it.
you got it.
Since it is connected, I will read up to 10, 11, and 12 Lordships. It is true that under Order 47, Rule 1, Sub Rule 2, applications for review can be presented even after filing up an appeal by persons other than the applicants for review. It is, however, also clear from its provisions that such applications for review presented after the filing up an appeal would be restricted to only such matters which could not be decided in the appeal by the non-applicant. A respondent can file an application for review if he is unable to present to the appellate court the case on which he seeks to apply for review. any other party can apply for review only when the ground of such appeal is not common to him and the appellant. It would appear that in such cases, the order of the appellate court will not be with respect to those matters which ought be considered by the court of review, and that, therefore, there is no expected to be any question of conflict of decisions or jurisdiction. In fact, the position would be that the subject matter of the decree sought to be reviewed would not be within the jurisdiction of the appellate court to interfere, and therefore, in substance, the position would be that the review application is with respect to such matter which is not under appeal. It appears to me that if an application for review can be perused to its logical conclusion after the subsequent filing of an appeal, the condition that an application for review can be filed against available decrees or orders, if no appeal has been preferred, would become nugatory by people resorting to filing review application first and appeal later on. Thus, the policy, whatever it be, which must account for the provisions of section 114, clause A, would be defeated. 12. Right of appeal has been expressed as a right of appeal against a decree or order. The right of review is not so expressed. It is rarely conferred on a person aggrieved by an order or decree. Order 7, Rule 1 does not say that any such persons may apply for the review of judgment, but says that any such person who desires to obtain a review of the decree passed or order made against him may apply for a review of judgment. Reference to the desires of a person aggrieved indicates to my mind that the person aggrieved of the decree or order has to make a choice of filing an appeal or an application for review, so long as limitation for appeal is available. It may be mentioned that limitation for the application for review is not less than limitation for appeal. The appellate court mainly sees whether the court below has passed a correct order on the materials before it. In case of review, the same court which passed the order sought to be reviewed has mostly to see whether its previous order requires reconsideration on account of the grounds alleged in the application for review. An application for review would ordinarily presupposes that the order on the basis of the materials before the court was probably a correct order. Evidence which could be looked into during the hearing of the review application could not have been available to the appellate court in view of the limited extent of Order 41, Rule 27 CPC. So far as this court is concerned, this rule has been amended and now authorizes the appellate court to receive such fresh evidence which could not have been made available to the court below. Thus, the appellate court can look into fresh evidences which is sought to be laid before the court which passed a decree or order. These circumstances then to show that once the matter is before the appellate court which has got a wider jurisdiction should decide the matter and not the review court which can look at the matter in a limited form only. In view of this, the review application which has been filed by the two review applicants, the prayer sought for in the review application is in respect of the two applicants who had responded number 44 and 45 in that writ petition. So even if the review application is allowed or dismissed, the grievance of the petitioners will still remain. Therefore, the only option for the appellants is to file an appeal before expiry of the limitation period. That is how this writ appeal has been filed. And it is not a case that the two persons who have filed the review application are the parties in this case. No. They are placed in a separate category now.
They are not appellants.
They are not appellants. So I feel that it will be prudent on the part of this honorable court to take up the
We were
appeal.
very anxious to find out
And
whether.
if there is any other difficulty, then I leave it to your lordships.
Yes, respondents, What do you submit?
Lordship, in the interest of justice, let the matter be fixed on 20. Apart from that, Lordship, we in the writ petition challenge the appointment orders of the present appellants. They were appointed without recruitment process and through backdoor. What can change their stance? Can they make themselves as a substantive appointees, Lordship? That is the only ground we approach this honorable court. Challenging their appointment order. Their appointment order is illegal, that's why it has been quashed. Is there any law to change the circumstances where their appointment can be made substantive, Lordship?
Where
It
is the judgment in appeal?
It's
Page
page 3832.
Also, the learned senior counsel is submitting contradicting the judgment order. Lordship will kindly come to page 388. What the learned advocate of the present appellant stated before this honorable court, and it has been page 389, Lordship. The last 389. Or allow me to read out from paragraph 5. This is the submission that has been recorded in the judgment order itself. Paragraph 5, Lordship.
Yes.
Page
Who are the appellants here?
6 to
45.
6 to 40, 6 to 43, 44 and 40, 44 and 45 are
Review.
yes, review petitioners. So that will mean 6 to 43. Now, Lordship, the submission of the respondent government 5, Mr. Sangtam, learned additional advocate general Nagaland, representing the respondent number 1, as well as Mr. Jamir, learned counsel representing the respondent number 2 to 19, have submitted that no counter affidavit on behalf of the state respondents has been filed in this writ petition, as in the batch of writ petitions involving similar issue, writ petition civil number 189 obliques 2022 to writ petition number 199 2022. A comprehensive affidavit in opposition on behalf of the state respondents was filed, and the stand taken in the said comprehensive affidavit in opposition would also cover the issue involved in the instant writ petition. They have submitted that the said batch of writ petitions, writ petition number 189 obliques 2022 to writ petition number 199 obliques 2022 was disposed of by a common judgment and order dated 29/2024. They have also submitted that as there is no difference in essence between the facts and circumstances obtaining the said batch of writ petitions, writ petition number 189/2022 to writ petition number 199/2022, and the present writ petition, the observation and direction made in the common judgment and order dated 29/2022 would also govern in this writ petition. This is very relevant, Lordship. The learned counsel for the respondent number 6 to 45, present appellants, has also submitted in similar lines, adopting the submission of the learned state counsel, and no counter affidavit has been filed on behalf of the respondent number 6 to 45. This is their submission, and the present submission before the honorable court contradicts, Lordship. We should go by the record. We cannot whimsically submit irrelevantly.
Was no submission made on the present appellant's behalf before the writ court?
No, Lordship, just adopted the submissions made on behalf of the state. And Lordship may kindly see paragraph 10 also, the same judgment,
Yes,
page 392, paragraph 10.
yes.
Ms. Zemomi, learned counsel appearing for the petitioners has submitted that the fact situation obtained in the batch of writ petitions, so and so, is similar to the fact situation obtained in the present writ petition, and as such, this writ petition shall also be disposed of with the same observation and direction. And a query, this is important. Query was made to whom? That will be more important. Lordship has just put a query on that. And a query made by this court to Mr. Sanktam, Learned Additional Advocate General Nagaland, appearing for the respondent number 1, and Mr. Jamir, Learned Counsel appearing for the state respondent number 2 to 5, on the point whether there exists any distinguishing feature in the manner of appointment of the present respondent number 6 to 645 from the manner of appointment of 935 numbers of constables, which was the subject matter of the common judgment and order dated 29/2024. We have fairly submitted that there appears to be a distinguishing feature in the manner of appointment
No,
in
no
the
distinguishing
two
feature.
seats of appointments. The learned counsel appearing for the other respondents, there my role will come. Of course, I was not there. Noted in paragraph number 1 above, have not also pointed towards any distinguishing feature between the two seats of appointments. The query was made to the Learned Advocate General and the counsel representing the state, and no query was put to the counsel for the petitioner, the present appellants. Now, Lordships are well aware that if a wrong submission is made by the counsel, that should not put the client in a disadvantaged position, Lordships. And the main trust, as I was submitting,
Therefore, the question was to go and file a review, because you come to page 89, 389, so rightly pointed out by my learned brother. You read page 389, the last lines of paragraph 5.
Sure.
389.
Yes, paragraph 7.
No, the last lines of paragraph 5.
Yes.
The learned counsel.
For the respondent number 6 to 45 has also submitted in similar lines, adopting the submission of the learned state counsel, and no counter affidavit has been filed on behalf of the respondent number 45.
Then it has been adopted.
Exactly, Lordship.
Now to say that, then you come to para 12 of page 395.
Yes.
It says in the admitted case of the parties.
It is admitted case of the parties that the order of the appointment of the respondent number 6 to 45 were made without any kind of advertisement and without following the principles which emanate from Article 14 and 16 of the Constitution of India. As there was no advertisement, the said act had deprived all the eligible. Lordship, I'm admitting from the day one that yes, admittedly, there was no advertisement. But a distinguishing feature can be made that Lordships are well aware about the observation and normativist case in paragraph 53 of the judgment, where the distinction has been made between the illegal appointment and irregular appointment. From day one,
Yes.
Mr. Jamir, why did you not argue all this before the learned single judge? At that moment, you had adopted that it is covered. If that is not correct, then you go ahead and file a review.
So Lordship, as I was submitting, for the lapses and the word of the council, the litigant should not be prejudiced.
All right, you tell us your grounds of appeal now.
Yes, Lordship. Number one, my submission will be on two folds.
Yes.
Firstly, Lordships, the contention of the
Judgment, relaxation.
Yes.
Lordships, before I go to the grounds, Lordships has also met an expression that why not you go for a review? Lordships are very aware. The scope of review is very, very limited. And I cannot take a new ground now in the review. So unless I file an appeal, even to go for the review, the scope will be very limited. That's why I have opted to file the review by way of challenging. First, submit contention of the writ petitioner is on two counts, that is backdoor appointment and illegal appointment. To that, Lordships, I'm making a submission that it is not in the backdoor appointment, it is a front door appointment, and it is not an illegal appointment, but an irregular appointment. That is why I'm coming to the paragraph 53 of Omar Dibi's case,
Irregular appointment can be front door.
which has been crystallized in the.
So if it is not back door, if it is not front door, it must be by the window.
So it has been crystallized in the ML Kesari's case that any appointment without advertisement, but if the employees are eligible and without following the proper procedure, then those appointments can be treated as a regular appointment. And subsequently, there are so many judgments, like in 2017, also Jammu and Kashmir's case, the Bar Association of Pandibara. In all these cases, the irregular appointment has been explained, deriving the principle from paragraph 53 of Omar Dibi's case, Lordships. So there is no recruitment rule. And the learned single judge in the earlier case has based the judgment on two judgments. That is Ajay Dibarma's case. Ajay Dibarma, which is based in the Danmoy case and the Pankaj Gupta. Both the cases are treated as illegal appointment. I also support that. Why it was treated as illegal? Because in Pankaj Gupta's case, the recruitment was made, the appointment was made under recommendation of the ministers, MLAs, head of the departments in the grade 4 post. So all these appointments have been treated as illegal appointment because the appointment was made in violation of the rules. Coming to the Ajay Dibarma's case also, there's in Ajay Dibarma's case, there was recruitment rule, recruitment policy. All these were not followed. The merit list was not maintained. Persons who are not eligible have been appointed. Persons who are in the merit list were ignored and not appointed. And the persons who are in the bottom of the select list who are not selected were also appointed. That is why it was treated as an illegal appointment. And in that case, the relaxation was sought for, but the relaxation was denied on the ground that the right to compulsory right of education, right of compulsory education to the children's Act 2009 and the NCT Act do not permit any relaxation. That is how the relaxation was not given. Side by side, the counsel for the state, who represented the state, has also made a concession that if this honorable court held that the appointments are illegal, then they are not entitled to any relaxation, they should not be given. That was the submission. Here it is other way around. The state was directed to file an affidavit during the course of the hearing. It was on, I think, 8th of August. An order was passed by this honorable court allowing the state to file an affidavit. Okay, if you want to grant relaxation, in what manner you want to grant relaxation, you file an affidavit. That came to be filed on 20th August 2024. That is the date of hearing of the first street petition, where the affidavit has explained how and in what manner the relaxation should be given. And in Ajoy Dibarma's case, which is based in the Danmoy Nuts case, relaxation was granted and the state government was allowed to frame a policy, new recruitment policy. Even that discretion was also given to the state in what manner it has to be done. But in any case, it has to be advertised. Yes. Relaxation was given to the serving employees.
Show us from the police manual.
Lordship.
What is the, your case is that the process for appointment is on the basis of the police manual, procedure prescribed in the police manual.
Moreover, Lordship, there is a relaxation. I have enclosed in page 26 of the appeal memo.
Lordship, the relaxation is prior to Uma Devi's case, landmark
26.
judgment. These people come under.
This was before Oma Devi's case, Lordship.
That's why they come under 10/4/2006 cutoff date. If they want, they come under that.
This
They were
was also
appointed
not
in
placed.
2018, 19, 20.
No. One of the grounds is that all the process was undertaken by way of, in terms of the police manual.
Lordship, in the police manual, rule 8.
You have a police manual?
Only one. It is misplaced. It was prepared, but
Yes. Wait, what is the rule number?
rule 8. That is for sub-inspectors.
Yes.
And then rule 13 is for ASIs.
So you have sub-inspectors and assistant sub-inspectors.
Yes.
As appellants.
Yes.
Sub-inspectors are by way of direct recruitment.
Yes.
And assistant sub-inspectors,
Rule 13.
is it by direct recruitment?
Yes.
And backdoor appointment is
There
not
are
direct.
sources from promotion from the head constable also.
All right. All right. Well, where is the, on what basis do you say that it has been followed? There must be some official communication indicating
Please come again, Lordship.
you, the fact, how, because there was no advertisement, there must be an official communication from the government initiating this process of recruitment. So is it available in the appeal memo?
No, Lordship. And the other one is page 26 of the
Of the
appeal memo,
appeal?
where the Director General of Police has been delegated to make appointment in the exigencies of service.
No, your police manual talks about constitution of some committee,
Yes,
interview board. So you'll have to show us that if you say the police manual has been followed, then these steps were taken.
that record I don't have. But the eligibility criteria, mode of appointments,
Okay. This relaxation is still subsisting. Relaxation given to the DGP, power to the DGP.
yes, this has not been superseded. If we were allowed to, if affidavit had been filed, I have no grievance that I was not allowed to file. We ought to have filed the affidavit in opposition in the case, but that has not been done. So if an opportunity is afforded to file affidavit in opposition and remand the matter to the learned single judge to rehear the matter, because of the fact that all the submissions which has been made in respect of the constables,
For that you'll have to satisfy us.
by relying on because the learned advocate general has also made a concession before the honorable court, before the learned single judge, that it is squarely covered. And a concession was also made to the effect that the state government has taken a decision to cancel all this appointment and decided to go for fresh recruitment. That was the concession given in respect of the constables. That was in another proceeding. But then that was made to be applied in the present case also.
Let us keep
And
aside,
with regard to the concession, Lordship,
let us keep aside the judgment of the constables away for the time being. You satisfy us that notwithstanding there being no advertisements, you admit that there is no advertisement.
yes,
So notwithstanding the advertisements, these selections which were made
yes,
are made under relaxations given by the government, or as you say, in terms of
yes.
the police.
Lordship, yes, on that point.
Yes.
During the course of hearing the writ petition in the constable's case, the earlier case, on 8/8/2024, an order was passed by the learned single judge that if at all the state government wants to grant relaxation, then you propose and you file an affidavit. That was filed on 20th August 2024. And it so happened that on the same day, the case was taken up for hearing, but relaxation was not granted, basing on the two judgments. That is why I'm referring to the Pankaj Gupta and Ajoy Divarma's case. By relying on these two judgments, the learned single judge has denied the relaxation. But I would like to submit that there is a vast distinction between the law laid down in Pankaj Gupta's case and also Ajoy Debarma's case. In both the cases, the appointment was held to be illegal. But I'm submitting that our case at best can be treated as an irregular appointment. Yes, because there was no advertisement. Now, in Ajoy Debarma's case,
Do you accept advertisement necessary or not necessary? Because your police manual does not talk about advertisement.
yes,
So if your recruitment is done by following the police manual, no advertisement is required.
the Lordship,
You have to be clear with your instructions, whether advertisement is necessary or not. If it is strictly by the police manual, then no advertisement is called for. But that is not your submission.
Lordship, for advertisement, I'm not saying that it should not be advertised because we have to go as per the law.
The
Law of the land.
Law means the law, the rules which are prescribed, which are followed.
Yes,
Read with the exemption given by the
The-
DGP.
Learned single judge has also held that the Nagaland Police Manual is a law under Article 13 of the Constitution.
Then,
So that provision has been protected in a way.
So therefore, if you insist on the police manual, then no advertisement it's not prescribed here. Advertisement will be required,
Yes,
but it's not your submission. You are saying advertisement is required.
I'm not saying that advertisement is required, but considering the nature of appointment, it cannot be treated as illegal.
It's all right.
It is an
All right.
irregular
Show
appointment.
us the judgments, we show us the judgments which are there. What do you want to rely on? You have enclosed here.
Lordship, with regard to the relaxation, I would like to place few judgments.
No, you are referring to Pankaj Kumar judgments.
Yes, Lordship.
So you want to say that the facts of your case are distinguishable from the judgments.
Yes.
Place the judgments, we'll have to go through the judgments.
Just my humble submission, Lordship. Even in the constable case, at the same time, there was an advertisement for 206 posts. In the a bunch of writ petition, it was enclosed. Even for a constable, there was an advertisement for 206 posts. Then 934 they did not advertise. That's why we challenge it. And those posts that was not advertised was quashed and set aside. So even a constable advertisement is there. So where is the criteria of partial pick and choose, going without advertisement, and half of it going for advertisement? And irregular appointment and illegal appointment. Show the law. Let the learned counsel show the law. Where after Uma Devi's case, prior to that, we will not indulge. After Uma Devi's case, at any point of time, the state government appointment in public service can be made after Uma Devi's case. Show the law. And they can call it, they can tune it as irregular appointment. Uma Devi case on 10/4/2006. Those who were irregularly appointed, that was the cutoff date. LM Kesari has already clarified it. On that day, those irregular appointment in a sanctioned post within 6 months has to be regularized. That was given. The cutoff date is 10/4/2006. After that, Lordship, where is the law? Where is the law? Anytime appointment can be made through backdoor and in a sanctioned post, and always it will go on in the state of Nagaland or in any other state in the country. Anytime they can appoint backdoor appointment, and they say that it is irregular appointment. Show the law. That's all.
Lordship was asking about two judgments. Pankaj Gupta's case. This is with regard to the appointment of grade 4 post, a short judgment. Here in this case, no rules has been followed and appointments were made on the basis of the recommendation of the ministers, MLAs, legislative councils and head of the departments. So, and no rule has been followed. So the appointment was held to be illegal in those cases. That is why when the appointment was illegal appointment, the relaxation was not granted in that case. That is one. Now, coming to Ajoy Debarma's case, paragraph 124 and 125. Ajoy Debarma is based in the Tanmay Nath's case, but why Ajoy Debarma is referred? Because a review application was filed under the name and style of Ajoy Debarma, where the paragraph 123 was modified in the Tanmay Nath's case. Otherwise, the comprehensive judgment is the Tanmay Nath's case. That is with regard to the appointment of the teachers. More than 10,000 teachers were appointed, and all appointments have been quashed by the Honorable Supreme Court Lordships. And then the Tripura government has came out with some different ideas that was found to be contemptuous, so contempt petition was filed. And all these cases were decided in the Ajoy Debarma's case. But the principle which has been decided in the Tanmay Nath case still remains, where the relaxation has been granted to the serving employees, although the direction was issued for issuing the fresh recruitment.
Yes. You're referring to?
I'm referring to Ajoy Debarma's case, but before that, it will be relevant to. Okay, let me just refer to Ajoy Debarma's case. Paragraph 2, Lordship. There was a bar for relaxation under the NCT Act of 1993. That is why the relaxation was not given. Selection of 10,323 teachers made by the government of Tripura pursuant to the advertisement issued in the year 2002, 2006, 2009 was subject matter of challenge before the High Court of Tripura in Tanmay Nath versus State of Tripura. While accepting the challenge, it was held by the High Court that the selection was contrary to the provisions of the National Council for Teacher Education Act 1993 and the relevant policies, and that the appointments were arbitrary and illegal. It was found out the selection was irrational and illogical, and that it suffered from nepotism and favoritism. In view of this, there is a bar under the Act not to relax also. And then kindly come to the extract of paragraph 125. Paragraph 123 is already modified.
You're referring to page number?
Page 70. 2028 is page 70. Under paragraph 2.2, paragraph 125 part Tanmay Nath's case is reflected. We would also like to make it clear that other than the benefits indicated by us above, there can be no reservation preference on the basis of each. There shall be no preference to dependent government servants or retired government employees or retrenched employees, etc. There can be no reservation for linguistic or religious minorities or on area-wise basis. It is further made clear that if the persons who are selected in the previous selection are again selected, then the service rendered by them earlier shall be counted for the purpose of seniority, pension, and all other purposes. Why I'm referring this is, in that case, in Tanmoynath's case, if in terms of the direction of the court, fresh selection is held, and the persons who were terminated and they apply again in terms of the fresh advertisement, if they are selected, then they will get seniority benefit and all other service benefits, including pension. That was the observation made in Tanmoynath's case. By relying on the Tanmoynath case, the constable's case were decided. But there is no observation in the judgment of the learned single judge about this aspect of the matter. And out of 935 constables, some of them may be selected. If they are selected, then are they required to undergo training? Again, that observation is also not there. And how to regulate the conditions of those persons were also not mentioned in the order passed by the learned single judge, especially for the sub-inspectors. We are trained under Ministry of Home Affairs. And on completion of our training, rigorous training, we took oath under the Constitution. Now, if there is a direction, assuming that there is a fresh order for fresh advertisement, and we were made to appear. And in fact, as per the learned single judge, we were allowed to appear for the interview. Now, if we are selected, can we be subjected to another rigorous training? That observation is also not there in the judgment.
Maybe. There is no absolute bar that you cannot be. Once your appointment is gone, it is gone.
But now that the judgment has been passed by relying on the judgment and the principle laid down in the Tanmoynath's case,
Sure.
this principle should also be equally applied.
Mr. Counsel, your primary case before the appellate court is that the constable's case verdict is not applicable in your case.
Yes.
So
Because
therefore, what judgments are relied upon in the constable's case? How is it relevant for your case if you say that these are not applicable to you? Now, in order to sustain your argument, you will have to convince us that these are the steps undertaken in your case, which makes it different and distinct from the constable's case.
yes.
Exactly.
Now, with coming to the relaxation again.
Is it only the relaxation?
Yes. That is also a primary consideration to be taken into consideration.
You have
by
not
the
pointed out the procedure which is given in the police manual, which has to be followed. Assuming the relaxation is given by the public by modifying the Public Service Commission, isn't it? That page number 26 relaxation you're talking about.
Yes.
Now, in spite of notwithstanding this relaxation, whether the DGP, while initiating a recruitment, is he required to follow the procedure prescribed in the police manual
Yes.
or not?
There, in terms of the manual, he has to constitute a port.
Has it been done or not?
No, that was not done.
So therefore, the short question is, should we dismiss it today or you want another date for it?
Exactly. That's
Heard, Mr. C.T. Jamir. Learned Senior Counsel assisted by Mr.
What Jamir and I.
And I am for the appellants and MS Z Simomi for the respondents, private respondents.
Yes.
And Mr. Jamir, who's appearing? Mr. Sankam for State of Nagaland.
For respondent number 1.
Respondent 1.
I am for 2 to 5.
Mr. Jamir for 2 to 5. This appeal is directed against the judgment and order dated 26/9/2024 passed in writ petition 317 of 2023, by which the appointments of the appellants to the posts of sub-inspectors and assistant sub-inspectors were interfered and set aside. Stop. The primary grievance of the learned senior counsel appearing for the appellants is that the learned single judge, while rendering the judgment under appeal, merely relied upon a judgment and order dated so and so
29/2024.
20.
Yes.
2009/2024 passed in writ petition 199 of 2022 and other connected bunch of writ petitions. Without
1892 to 199.
189 to 199, other bunch of writ petitions. Solely on the judgment and order rendered by the coordinate bench. So such recourse was undertaken by the learned single judge in the present proceedings on the basis of the submissions made by the councils representing the parties, including the present appellants, except including the present appellants. Stop. A perusal of the same judgment and order reveals a pointed query was made to the councils of the bar as to whether the judgment dated 2009/2024 passed in WPC 189 of 2022 to 199 of 2022 covers the issues raised in the present issues raised in the present in the writ petitions. Stop. The councils, including the council who represented the present appellants as who were arrayed as private respondents. Private respondents 6 4 to
20.
6
No,
to
no.
20.
6 to 20.
6 to 20. Submitted before the court that the issues stand covered. Under such circumstances, the writ petition was allowed and similar directions interfering with the appointment orders of the present appellants were issued. So, learned senior counsel submits that he would like to demonstrate that the factual issues, factual metrics in the present proceedings are different from the ones relating to the recruitment of constables of Nagaland police, which came up for consideration before the coordinate bench in WPC 189 of 2022 to 199 of 2023. So, learned counsel for the appellant further submits that the present the recruitment of the present appellants to the post of sub-inspectors and assistant sub-inspectors was undertaken in terms of the Nagaland Police Manual, more particularly rule number
8 and 13.
8 and 13. Stop. He further submits that the Director General of Police, Government of Nagaland,
Page 26.
has been conferred with, has been delegated the power of recruitment of unarmed branch SI, UBSI. And what is ADSI? Armed Division.
Armed branch.
ADSI, Armed Division SI, in the Nagaland Police, with effect from 24th of September 2004. Learned Senior Counsel submits that this relaxation is still in force. So accordingly, all these recruitments to the present appellants were made under the powers conferred on the DGP by following the procedure prescribed under the Nagaland Police Manual. So he submits that the Nagaland Police Manual does not prescribe publication of any advertisement. So he therefore submits that the learned single judge the conclusion arrived at by the learned single judge, placing reliance solely on the judgment and order dated 2009-2024, passed in WPC 189 of 2022 to 199 of 2022, which pertain the recruitment undertaken by the police constables, ought not to have been done, and consequently, the impugned judgment and order dated so and so, passed by the learned single judge, and which is presently under appeal, needs to be interfered and set aside. Stop. He submits that the judgment in the police constable was rendered by placing reliance on the judgments of the apex court rendered in Ojoy Dev Burma, reported in so and so, and Tanmoy Nath is reported in so and so, as well as Pankaj.
Yes, Pankaj
As
Gupta.
well as Pankaj Gupta, reported in so and so.
Lordship, Tanmoy Nath is not reported in the this thing, but then I could get it from the SEC
You write
online.
Pankaj Gupta and Ajoy Dev.
Ajoy Department is reported, but Tanmoy Nath is not reported.
We have a printed copy of
Yes,
SEC online.
I have.
We have a copy.
I have furnished already.
We have a copy.
Yes.
No, was Tanmoy Nath referred by the
Tanmoy Nath is referred in Ajoy Department's case.
but not
Otherwise,
not
case is same. Name is different.
independently, it was not referred.
Yes.
Ajoy Dev Burma and Pankaj Gupta, relying on these two judgments, the judge, the High Court, the coordinate bench of the single bench of the High Court, a single bench of the High Court rendered interfered with the selections by the constables of the Nagaland. So, referring to the judgments of Pankaj Gupta and Ajoy Dev Burma, Learned Senior Counsel submits that the factual metrics in these two cases are distinguishable from the factual metrics involved in the present proceedings. So he further submits that Ajoy Dev Burma case or the judgment of Ajoy Dev Burma was rendered by placing reliance to Tanmoy Nath case. The judgment of Tanmoy Nath rendered by the apex court in so and so. Stop. Whereas the further contention of the learned senior counsel before the court is that the concessions made before the learned single judge by the state respondents, state councils, as well as by the council representing the present appellants as respondents number 6 to
20.
was not based on the correct position as reflected from the records. He therefore submits that for the wrong submissions or for submissions made by councils without adequate instructions which led to certain submissions being made, which are found to be not borne out of the records, the present appellants cannot be allowed to suffer for no fault of theirs. He submits that had an opportunity been granted to the present appellants to bring all the materials on record by filing proper affidavit, the judgment under appeal in its present form would not have been rendered. Stop. He submits that perhaps the present appellants were of the belief that the relevant records and materials will be placed before the court by the state councils and by the concerned department. He therefore submits that this appeal be admitted and the matter be heard. The appropriate, the relevant records be called for. And upon due examination, the court should interfere with the impugned judgment and order dated so and so, passed in WPC so and so, which is presently under appeal, and allow the appeal until the matter is heard and decided. Adequate interim orders be passed. So, better. MSZ Zimovi, Learned Counsel, appearing for the private respondents in the agreed appeal, strongly disputes the submissions made by the Learned Counsel for the Senior Counsel for the appellant. So she submits that there is no dispute that these appointments to the posts of sub-inspectors and assistant sub-inspectors were made without advertisement. Stop. These appointments are all illegal appointments, and therefore the High Court in by judgment dated 2009-2024, passed in WPC 189 of 2022 to 199 of 2022, had examined the entire matter in detail and had therefore concluded that appointments made to the constables, appointments made in respect of the recruitments to the constables are required to be interfered with, and the same had accordingly been interfered with. Stop. Any appeal filed against that judgment?
No.
To the
To our knowledge.
it is submitted that to the best of the knowledge, no appeal has been preferred against the same judgment, and therefore the same has attained finality as on date. Stop. She submits that in respect of the sub-inspectors and assistant sub-inspectors, recruitment also, no advertisement was followed. All these people who are presently the appellants were appointed in an arbitrary and a pick and choose manner, and therefore the decision rendered by the coordinate bench, rendered by the single judge in the recruitment for constables, clearly applies to the factual fabric of the present factual fabric of the recruitment of sub-inspectors also. Stop. Under such circumstances, the state councils as well as the counsel who had represented the present appellants before the single bench had fairly submitted before the court that these issues are covered by the judgment rendered in by single bench in WPC 189 of 2022 to 199 of 2022 dated 2009-2024. So it is further submitted that two of the private respondents before the single judge had in the meantime preferred a review petition, being review petition number so and so, and the learned single judge is presently in session of the matter. So she therefore submits that besides the appeal having no merit to be admitted, it is appropriate to defer the matter. That it is appropriate to await the outcome of the orders that may be passed in the review petition. Is that your submission? We are
Yes.
recording it.
Which is fixed on 9th.
Which is fixed
19th.
on
No,
19th.
19th.
2022. 2024. So, under such circumstances, she submits that your submission is for what? Deferring the matter?
That will be appropriate, Lordship, because
Submits that.
they file after the review. Review
The
was
matter be
specified.
deferred till after orders are passed in the review petition, which is pending. So, there are anyone from the government to submit anything?
It will be proper if the battery is heard after disposal review.
All right, learned counsel representing the respondent.
225.
225, as well as learned additional AG representing the state. Respondent 1. Also submit that since the review petition has already been, what is your submission? You adopt the submission of since the review petition has already been filed and the matter is pending before the single judge, the appeal should be listed on a date. The appeal should be listed immediately after 1911, on which date the review petition is fixed. There are learned counsels for the parties have been heard. The appeal memo has been perused along with the judgment, the appeals. Stop. Judgments placed before this court by the counsel for the appellant are also carefully taken note of. Stop. There is no dispute that against the judgment and order dated so and so under appeal, the two of the respondents before the learned single judge who are not appellants here have already preferred a review petition, being review petition number so and so. One or two reviews? One review.
One review.
Review petition so and so. Stop. The review petition was earlier fixed on 8th of November, and the same and the parties and the councils before the court submit that the matter has been now fixed on 19th of November 2024. Stop. On
It was on 6th.
6/11. On 6/11, when this matter had come up, this court had also, taking note of the review petition file, deferred this matter and fixed it today. Stop. Accordingly, this matter now stands deferred. This court is of the view that the matter should be listed on, give us a date. Give us a date.
21st,
So I think 20 is your day for. division.
immediately after disposal of the review application, after the order is passed in the review.
You are presuming we'll grant you an interim.
27.
27.
27, yes, because 19.
All right, 27th of November. 27th of November. The
Lordship,
the
December.
the issues urged before this court by the learned senior counsel for the appellant will require some consideration. More particularly, on the basis of the records which may be necessary to be perused by the court. Records of the department. Stop. Under such circumstances, although it is also noted that in view of the submissions made before the learned single judge, before the single bench, no counter affidavit was filed. State did not file, as well as the police department. None of the respondents before the single judge, including the present appellants, filed any counter affidavit. So, under such circumstances, it may be necessary for the court to examine the relevant records of the department to verify the claims made by the appellants before this court. Stop. Considering all these aspects, we direct the parties to maintain status quo as on date till the next date fixed. Stop. Further orders in the matter will be passed upon such orders as may be passed. Further orders will be passed on the next date fixed.
Lordship.
You place the orders before the court.
Lordship.
Have you been served with copies?
Yes.
Okay. Anything more?
Obliged. Lordship,
Yes.
in the appeal, my name has not been reflected.
Registry to reflect the names of all the councils.
My juniors' names are there, but not my name. ZG.
MSZ, Rimobi, Learned Council for the respondents number 6 to
6 to 20.
along with the names of Mr. T.B. Jamir for respondent so and so and Mr. Saktam, additional AG for respondent 1. Along with these Momi, be reflected in the cause list.
Lordship. Obliged, Lordship.
Yes.
For admission, item numbers 5 and 6.
Your Lordship, on last occasion, condoned petition was, the delay petition was condoned and
It was
which,
admitted. Delay was condoned.
delay
Yes.
was condoned. And from the records, there is no calling of below court records.
Heard. Learned, you're Mr.
VTO.
V. Theo, learned counsel for the appellant, and Mr.
Kiangami,
K.
Lordship.
Angami, learned governor, PP.
Lordship.
PP appearing for the state. This is an appeal directed against the judgment dated 9/2/2024, passed in what is the case number? GR case 46. GR 46. Case number 46. 46 in connection with 46 within bracket PEG woman BS case number 1 of 2023 under section 376 within bracket 2 bracket close again bracket H bracket close slash 354 IPC read with section 4 and 8 POCSO. Stop. Call for the records, connected reports from the concerned court. Notice be also issued to the family of the victim.
Lordship, that has been done, Lordship.
Has been done.
Yes. That's already on record, Lordship. Already on record.
Not reflected in the.
Not there.
This thing.
It's been,
that
I
is
think it's been recorded. It's been recorded. It's all been recorded.
Yes.
Recorded
They've been
where?
informed.
Yes, yes, Lordship.
It's not here. There's no office note. All right.
In the condolation application
Yes.
that are disposed of, I.
Copies of the appeal, along with the bail memo, be also furnished to the guardian of the victim.
Yes,
Your
all
Honor,
these
it's
things.
been already
All
finished.
this is raised.
And it's noted on 11/9/2024.
You have already.
There was direction by this court.
Is it the IA or the entire appeal?
Through IO, it was informed to the victim.
You don't know. Have you served the copy of the appeal also?
Your Honor, Your Honor.
Yes.
Then you write that it is submitted by the get the order date. That by the councils at the bar that the victim / her family members have been served with the notice, a copy of the appeal memo in term as reflected in the order dated 7/8/2024 passed in IA number so and so. Stop. Let the matter be listed for hearing.
Lordship, paper book may be required.
Paper book necessary.
Yes, Lordship.
Paper book necessary.
Lordship.
How many witnesses?
About 24. Prosecution witness, 24.
Okay, let the records come. No?
Lordship.
We'll need it. Let the records be called for matter be listed again after 2 weeks, 3 weeks.
3 weeks, Lordship.
3 weeks. In the bail, you write bail application number 14 of 2024. Heard learned counsel for the parties issue notice. Steps be taken for service of notice on the victim / family members through the OC of the jurisdictional officer in charge of the police station.
Lordship, actually, all this notices.
It was served. It was
Okay,
served.
Separate.
Okay.
If not already served.
Okay, Lordship.
served on so and so, if not already served. Let this bail application be listed along with the criminal appeal.
Bless you.
For admission, item number 7.
My lord, I have not yet received the instruction, so this matter will come after three
Instruction
weeks.
not received. Somebody objected to. Yes, what do you say?
Lordship, with regard to these items number 7, Lordship, 2 weeks has already allowed in previous order. That is 16 October 2024.
This is the PIT and DPS.
Yes, Lordship.
When were you detained?
So, Lordship,
35. Since when were you been in custody?
she has been since 3rd of September, Lordship.
September, okay. We give him another 2 weeks. Please file your response.
Yes, my lord.
You are for the
Respondent for my lord. CG and for Minister of Home Affairs, my lord.
May I please, Lordship? My lord, I may bring for respond number 1, 2, and 3. I have already filed.
All right. Learned APP, your APP. PP.
Yes.
Learned PP, appearing the respondent 1 and 3 submits that the affidavit has already been filed. And learned counsel appearing for the respondent number 4.
Yes, my lord.
Prays for 2 weeks further time, file the response. So counsel for the petitioner submits that the petitioner has been in custody since September. And therefore, urgent hearing is required. Accordingly, let the matter be listed after 2 weeks.
Much obliged.
For admission, item number 8.
Yes. Yes, who's for the petitioner? None appears.
Lordship, my senior will be appearing by VC twice.
Yes, Mr. Manna. We can't hear you. You're not audible. We still can't hear you. Need to reconnect again. We will call it up after a while. After a while.
For admission, item number 9.
Yeah, I'm for respondent number 1, 2, and 3, Lordship. I'm yet to receive instruction. If Lordship may please to grant 2 weeks time.
Heard Mr. Moajami, learned counsel for the petitioner, also heard Mr.
Digimomi,
So and so learned counsel appearing for
respondent 1, 2, and 3.
1, 2, and
1, 2, and 3.
1, 2, and 3. And
And
Mr.
four.
So and so learned counsel appearing for respondent number 4. As prayed for by Mr.
Digimomi,
Rizwami, learned counsel for respondent number so and so, list this matter after.
I said 3 weeks. By 2
3
weeks,
weeks. Any objection?
2 weeks, Lordship, a little bit 2 weeks.
By 3 weeks, I admit, I got the
Fixed by the registry to enable
You're-
the said respondent to file objection in the matter.
He's under detention,
Since March, Lordship.
so you get your instruction.
This is, they have withdrawn and they are filing at place.
All right, you see if you can get it by 2 weeks. Possible.
For admission, item number 11.
May I please, my lords.
Yes.
Lordship, I'm for state respondents. Lordship, I'm, can you, grant me 2 weeks time to obtain the instruction and to file an affidavit, Lordship?
Lordship, the detainee has been in detention since 12 July. If the last chance may be given granted and if the matter may be fixed on 4 December.
Yes.
Lordship, I'm yet to receive instruction.
As prayed for by Mr. So and so Long Kumar, right?
K. Angami, Lordship.
K. Angami, Leonard, counsel representing respondent numbers
1, 3, and 4.
1, 3, and 4, comma. List this matter on 4th,
4 December.
4/12/2024 to enable the said respondent to file affidavit in opposition in the matter. So it is needless to be clarified that since the issue involves is detention of the petitioner, no further adjournment for filing affidavit in opposition shall be granted by this court.
Your Lordships, may I be permitted to file an additional affidavit just to include some additional?
Mr. So and so, Leonard counsel for the petitioner is at liberty to file affidavit in reply if need be.
Obliged.
From the supplementary cost list for admission, item number 24.
Lordship, even here, I have similar prayer, Lordship.
May it please, my lords. Lordship, on the last occasion, 4 weeks was already granted. And this is a habeas corpus matter, my lord. A single day is a day too many, my lord. And procedural lapse are apparent on the records, my lord. Therefore, the matter may kindly be heard today.
Supplementary. Respondent number 2, I yet to file affidavit in opposition. I have not received any instruction letter.
You have a respondent 2.
Yes, my lord.
Respondent 2. Who's issued the order? Chief Secretary.
The Special Secretary Home, respondent number 3.
Special Secretary. Who's for respondent 3?
Lordship.
You get your instructions because
Yes, it's Lordship, 2 weeks, Lordship. Item, in fact, item number,
we'll fix the matter on 27th.
Lordship, Lordship, item number 11 and 24. I think from the same case, so if it can be taken up together, I think the council petitioners are the same.
Same FIR.
Same FIR.
Yes, my lord.
Then we'll have it on the same date.
4th December.
4th December. What was the earlier item number? 11.
11.
Same order.
That be the name of the petitioner.
Obliged, my lord.
For orders, item number 12.
May I please, your lordship? Notice upon respondent number 1 was issued on 4/10/2024.
Awaited.
No, I'm appearing for respondent number 2 to 5.
Oh, why?
My lord, if I may be able to take your lordship to the order 3/10/2024. In the last paragraph.
Yes, have you served copies on respondent 1?
Yes, my
You
lord.
served it?
Yes, my lord.
Then you need to file a affidavit.
My lord, the compliance order affidavit I've already filed.
You filed.
Yes.
Where is that affidavit? Compliance affidavit? Aye. What was the IA for? Delay.
Yes, lordship. Delay was condoned on 4/8/2024.
My lord,
14/8.
No, where is the
Yes, sir.
compliance affidavit of?
no, my lord, sorry, my lord, I've served the notice on 4th day in 2024, but acknowledgement received, I have not received.
File it.
Yes, my lord. So kindly allow me 2 weeks time, my lord.
Week for filing a receipt.
Okay.
1 week.
No, my lord, until I receive acknowledgement receive, I cannot file it.
No, but you are certain that you have served.
Yes, I have already sent.
You have sent it.
Yes, my lord. Through the department, I have sent it.
All right. In terms of the order earlier. In terms of earlier order 3/10/2024. Steps were taken by the petition appellant on respondent number 1 by registered AD. Stop office note, however, reflects that service is awaited, service report is awaited. Stop. In addition thereto, the council representing the state was also directed to take steps for service of notice on respondent number 1. Stop. Mr. Pom, the council appearing for respondents 2 to 5.
Yes.
Submits that he has taken steps.
Yes.
He has already sent to the concerned department for service on respondent number 1.
Yes.
However, he is yet to receive the acknowledgement. He prays for 2 weeks' time. Let the matter be listed after 2 weeks, by which time the State Council will also file an affidavit of compliance regarding service of notice on respondent 1 in terms of the order dated so and so.
Much obliged.
For orders, item number 13.
Counter affidavit not filed, CGC.
Lordship, after going through the records, affidavit is not necessary since it is an appeal, it can be taken up.
So. Learned CGC submits that after perusal of the appeal memo, he finds that no affidavit is necessary as this is an appeal. And counter affidavit was filed earlier.
Yes.
Counter affidavit filed before the learned single judge will be sufficient. What is this appeal against?
My lord,
Combination.
dismissal of Assam Rifle Constable.
Right, then it has to be admitted.
My lord,
Then we admit it.
my lord.
Heard learned counsel appearing for the appellant as well as for the respondents. This appeal is directed against the
Judgment order dated
Judgment.
25/2024.
25 2005-2024 passed in WPC 72 of 2021.
my lord.
So admit. Matter be listed for hearing.
In the usual course.
No, what usual course? This is a dismissal. Let the relevant records of the proceedings against the appellant be called for from the respondents. Matter be listed after 3 weeks.
My lord,
3 weeks.
much obliged.
For orders, item numbers 14 and 15.
Please, your lordships. Lordship, as allowed by this honorable court on 18/9/2024, I've taken steps upon 12 different respondents, lordship, by way of registered post as well as the assist service. I have filed an affidavit to that effect, lordship. I've served upon all the 12 respondents except respondent number 35, lordship.
This I is for?
I is for continuation of delay, lordship. There's a delay of 179 days, lordship.
Where is that? Where is that affidavit?
Affidavit, lordship, I have filed on the 7/11/2024, lordship.
Where are the acknowledgements?
Lordship, it starts from page number 12, lordship. Page number 12, lordships will find acknowledgement receipt in respect of respondent number 21, lordship.
How many delays? How many days of delay?
179 days, 179 days, lordship.
Why the delay?
Lordship, I have explained.
Para?
Lordship, kindly come to paragraph 3, lordship. Paragraph 3, paragraph 4, lordship. For particular paragraph 4.
Yes, any objections?
My lord, I'm for respondent number 17, who was the writ petitioner. I have no objection when we go for condonation of delay.
All right. No? Heard. The petitioner as well as counsel appearing for respondent 17.
My lord.
And the state counsel, Mr. V. Zamoni. So this appeal is directed against the judgment and order dated
Page
21/09/2023.
Lordship.
Passed in WPC number
171 of 2018.
171 of 2018. Stop. Sorry, not appeal, huh? You write, the petitioners preferred an appeal against so-and-so judgment. Stop. While preferring the appeal, there was a delay of 179 days. And accordingly, the instant IA has been filed seeking condonation of delay. Stop. The notice in the matter was issued on 23. Sorry. On 24/4/2024. And the, which order is it? 18/9, on 18/9/2024. The respondents 21, 22, 24, 26, 30, 31, 32, 34, 35, 43, 47, and 50 were directed to be served notice by Dusty. Stop. In pursuance to this order, the applicant has served notice on the by way of Dusty on the said respondents on 19/9/2024. And an affidavit of compliance to that effect has been furnished before this court, which reflects the receipt signatures of the, which reflects the acknowledgement of the concerned respondents. Stop. However, none represents the respondents today when the matter is called up. We have perused the grounds urged for seeking condonation of delay. Stop. No objection has been filed by any of the respondents. Stop. Taking into consideration the submissions of the learned counsel for the applicant, together with the grounds urged in the IA, we find that the explanation provided in the IA appears to be sufficient for us to take a view that the delay of 179 days can be controlled. Which 179 days which had occurred while filing the accompanying appeal can be controlled. Stop. Going through the grounds, we don't find that the delay had occurred because of latches on the part of the appellants, or is an attempt to resort to dilatory tactics to delay the implementation of the order passed by the learned single judge in WPC so and so. Stop. They accordingly accept the prayers and condone the delay of 179 days that had occurred while filing the accompanying appeal. Stop. I accordingly stands allowed and disposed of. The registry is directed to number the accompanying writ appeal and listed before the court on the next available division bench.
Not sure.
Much more.
My law official.
Okay. How many matters? Which item? Which item? 16 to 18. 16 to 18. You want to argue this matter? Is it? No, we have no difficulty, but only thing is that whether we can wind up today, the arguments.
I don't know. It takes some times.
Only, it is only the councils who know
Where-
how much you have to argue.
I'm challenging the rules. Yes.
Lordship, here I have raised one objection. The petitioner, he is challenging the virus of Rule 33B of the Nagaland Police Manual, which provides for maintaining separate seniority lists for armed and unarmed branch in the police.
Seniority list.
Seniority list. Say, according to the petitioner, they should have a common seniority list for both armed and unarmed branches. But Rule 1 especially provides that it is the Nagaland Police is divided into two force, division of force.
That's on the merit part. When
No. Now, what I'm saying is that without challenging Rule 1, he cannot challenge Rule 33B.
No, that's on the merit part.
Lordship.
We are asking you, number one, I find that when notices are challenged, normally rules and statutes are challenged. At least there was a circular that notice should go to the office of the Advocate General. I don't find such orders here. This is one.
It is not there. It is
Right.
not there.
Second is, we can proceed with the hearing if you think you are able to complete, because unless we complete the hearing, your division benches are fixed on only one day.
Lordship. And
Then in that case, may not be able to finish today, latter part. Because I'll take little time, because three batches of petitions are pending.
Separate council.
Separate, no, what, councils, but three different petitions.
All right, then you give us a date when you want us to fix it.
on 27.
No,
maybe
my
it is
lord,
convenient.
I have already fixed one division bench matter in this morning, on 27th.
27, you're
On,
wrong.
I have already fixed one division bench matter on 27th. So it has been, my lord,
27. Or you want a separate date?
My lord, see, that is either 4 or 11.
On
Wednesday, with
On
DB
fourth.
matter.
Item 16, 17, 18.
Yes.
Be listed for hearing on 4th
No.
December.
For December.
As prayed for by councils. For appearing for the parties. List accordingly.
Much of
Oh, gosh.
It's not here.
Let me call out if he's there, he will join.
Right.
For admission item number 8.
Right, be listed on next Wednesday.
Next, my lord.
The counsel for the petitioner was attempting to join through VC. However, because of, yes,
Lordship, my senior will join by 2:30 because he have matter in High Court.
so we posted on Wednesday.
Wednesday,
Because we are at the end of the list
Yes.
and there is a single bench also. So till 2:30, we can't wait like that. Right? Learned counsel for the petitioner attempted to join through the VC, however, because of some technical glitch, it was not possible. The counsel was not audible. Under such circumstances, we deem it appropriate to fix the matter on the next available division bench, which is on
20.
20.
Yes.
20. List accordingly. So Leonard counsel for the petitioner and Mr. Bob
Yes, my lord.
appears for the Leonard APP for the state.
PP.
Leonard PP,
PP,
sorry.
yes, my lord.
Sorry, for the state.
Much obliged.
Hello. Is the court master sir available? Hello.
Yes.
এইটো কিবা নাগালেণ্ড মিউনিচিপাল এক্ট 2001 to
For orders, item number 1.
What is it? Result? 1, 2.
Roger,
Yes.
I'm for the Union of India. I have not received any instructions so far. So I'm looking some.
My lord.
Item
1.
Yes.
Yes, Lordship. I'm appearing for the Income Tax Department, my lord. 225, my lord.
Okay.
Peaceful act of good. Peaceful order.
Exemption. Exemption matter.
Lordship. In fact, this case also, my lord, they filed appeal, my lord, before the appellate authority, my lord, which is pending, my lord.
Oh. Have you filed appeal?
Yes, my lord. Now, what happened in this case is, Lordship, during the pendency of the appeal, I've been compelled to approach this court because penalty notice was issued against me, despite me responding to the notice, Lordship, saying that the appeal is pending before the CIT. So the penalty, the demand notice be kept in abeyance, but still they said, no, we don't, they have still issued the notice.
So you have to make a pre-deposit.
Lordship, and also they have issued a notice, demand in area, Lordship, giving me a specified date to deposit the whole amount.
See, once an assessment is done,
Lordship.
that assessment order will contain the demand notice.
Yes, Your
So
Lordship.
if there is a demand found against you pursuant to assessment, then that notice is, demand notice is there trying to recover that amount from you. If you go in a appeal, statutorily, it is provided 25 or 30% you have to deposit of the demanded amount.
Yes, as per the OM, it's 20%, Lordship. But then that is non-mandatory, Lordship. The assessment officer has the discretion, Lordship, and also, and kindly allow me to, for the reference of this court, Lordship, kindly allow me to refer this judgment passed by the Allahabad High Court, Lordship. In a similar case, Lordship.
We have judgments of Gauhati High Court which are binding on me. We have judgments rendered by this court.
Single bench.
This court.
I see, Lordship.
So which are binding on me, I am bound by my own judgments. So if you want to file an appeal, there is a statutory deposit you make until and unless it is waived by the appellate authority. If they waive it, good.
Lordship, yes. Lordship, kindly allow me to file appropriate application then, Lordship.
We did that yesterday, I think.
Yes, I think so. In a
Mr. Setia, similar orders?
Lordship. In fact, my lord, the assessee has the option to, my lord, apply before the assessing officer also, my lord, under section, Lordship, 220 subsection C for waiving the pre-deposits, my lord, for staying the disputed demand, my lord. They can move an application either before the, my lord, assessing authority or before the appellate authority, lord. 220
Six,
subsection
Lordship,
6,
six.
my lord.
226, Lordship. That is before assessment authority. Assessment officer. Since the matter is before, Lordship, kindly allow me to read the provision, Lordship.
No, see. You have filed an appeal against the assessment.
Yes.
Appeal is pending.
Appeal is pending. I have not.
Agreed by the demand notice, a persistent demand made by the.
Yes, and also, yes, Lordship, and the penalty.
Is the illegality here? That demand and penalty is made pursuant to the assessment order.
Yes, Lordship.
So until and unless the assessment order is interfered or suspended or stayed, demand will follow.
Okay, Lordship, if that is the case. However, Lordship, now since, allow me to kindly read the provision, Lordship, to kindly apprise this court. Yes, Income Tax Act, Section 226.
Two 26.
Yes, 226.
Yes.
Where an SSC has presented an appeal under Section 246 or Section 246A, the assessing officer may, in his discretion and subject to such condition as he may think fit to impose in the circumstances of the case, treat the SSC as not being in default in respect of the amount in dispute in the appeal, even though the time for payment has expired, as long as such appeal remains undisposed of.
Yes,
So-
have you applied?
I have not applied because there is no portal being made available to me, Lordship. Now, I was awaiting, Lordship, I was awaiting some decision from the appellate authority, Lordship.
So we direct them to, you will direct
Yes.
you to go and apply under 226.
Oh, Lordship, let me put up appropriate application before the Commission of Income Tax, because they also have the power, Lordship, to decide based on the merit, Lordship.
Oh, you have to file it before the appropriate authority.
Yes, my appeal is pending before their Lordship. In fact, I received notice also, Lordship, to submit my written argument from the Commissioner of Income Tax. Lordship, I have a copy with me. Just allow me to kindly furnish it. Lordship, this is the notice that latest notice that I received. However, Lordship, this was issued on 6th August 2024. And it says it has given me direction to submit my written submissions before the specified date. So I have, since the matter is pending here, Lordship, I have responded by saying that, presenting the truth before the Commissioner of Income Tax Appeal, saying that the matter is pending in the High Court. And also there is an interim order, Lordship. So this is my reply, Lordship.
What is the procedure, Mr. Setia, for deciding the appeal?
Lordship, procedure is prescribed, my lord, in section 249, my lord.
And 251, Lordship.
My lord, under 249, my lord, subsection 4, my lord. The appropriate application may be preferred, my lord, for staying the demand, my lord, during pendency of the appeal, my lord. And my lord, 251 prescribed, my lord, for disposing of the appeal, my lord, by the Commissioner of Appeals.
Yes, this is the provision.
Lordship.
249(4).
My lord.
249(4). There is a provision for filing an application for staying the demand.
Yes, Lordship. So allow me to do that then, Lordship. Because,
We're not stopping you from doing it.
yes,
We're asking
Lordship.
you, why have you done it if you have not done it?
No, because I have filled up the form, Lordship. The only communication that I received was to file my written submission. As there was no portal available, Lordship, that is the problem. Lordship, kindly allow me to show you an example of how it is electronically done. The department.
How is it to be filed, Mr. Setia?
My lord, it's through online, lordship. The similar way the appeal was filed, my lord.
Lordship, I have to log into my PAN card, Lordship, which is registered with the income tax, Lordship. If you see this only above, this is my ID. This is how they need to give me a portal. Then, if you see this, Lordship,
You're saying the portal is not working.
no, they have not given me the portal to file. That is the problem, Lordship. No, notices are given. If you see, Lordship, in this, they send notice like this. Notice will be there. There will be space for me to give my response.
Mr. Setia, what is it that portal is not available?
My lord, in this respect, my lord, I have to take instruction, lordship. Otherwise, my lord, the procedure is, my lord, in the similar way, they have to.
Every little thing that comes up during the course of the hearing, you can't make a prayer for getting your instructions. Either you ask your income tax officers to be present with you.
Lordship.
Every little thing, if we have to adjourn a matter, asking for instruction, why the
Lordship.
instructions are not available? Whether
Lordship, the,
it is working, not working.
because otherwise, lordship, it has to be filed electronically, lordship.
You take instructions within 5 minutes, we will resume the hearing again.
Lordship.
You find out whether the portal for filing an application, praying for stay.
My lord.
In respect of an appeal which has already been filed is available or not, and what is the procedure?
Lordship.
Get it, we'll take it up before 3 o'clock.
My lord.
From the supplementary cost list for hearing item number 4.
Yes. You are relying on the submissions of the Lokayukta?
Yes, Lordship. So far as the jurisdiction of Lokayukta is concerned, Lordship. Lordship, my second submission, Lordship, is that the respondent 5 to 9
Yes.
are the direct recruits BGD, batch of 2004. Lordship, the service conditions of the petitioner and the respondents is governed by School Education Service Rule 2002. Lordship, as per the rules that was applicable during that period of time, Lordship,
Yes.
Lordship, may kindly come to page 15th of the rolls, schedule 3.
Yes.
The next promotional boss of postgraduate teacher is to the boss of vice principal, who served for 12 years with B8 Lordship.
Oh, let us understand one thing.
Yes, I'm coming to that, Lordship. I'm coming to that. We are concerned about the B8 certificate possessed by the petitioner.
You are not the petitioner here.
Yes,
Petitioner is challenging the order of
Lokayukta.
What do you call reversion
Reversion to
on the basis of an order passed by the Lokayukta.
Lordship.
Now, our examination by this court is on two counts.
Lordship.
Number one is whether the Lokayukta has the power to do so.
Yes, Lordship.
Number two, even if it has the power, whether it should have been done, could have been done, etc.
Lordship.
Now, whether the petitioner is qualified vis-a-vis the private respondents is not an issue before us.
Lordship.
So where?
So, Lordship, we kindly come to a circular issued by the Department of School Education, Lordship.
No, whether
that is the basis of the complaint which was lodged by the respondent number 59.
We are not into the merits of the complaint.
Lordship.
Because that is not before us.
Lordship.
What is before us is the challenge made to the order of the Lokayukta.
And the reversion of the petitioner.
These are the only two grounds.
Lordship, Lokayukta order was passed based on the complaint lodged by the respondent 5 to 9. What is the complaint, Lordship? Kindly peruse my complaint, Lordship. Whether it's a complaint involving grievance or complaint involving allegation, Lordship. Therefore, Lordship.
Where is your complaint?
Before complaint, Lordship, we kindly come to page 30 of the writ petition.
3030.
30, Lordship.
Yes.
This is circular dated 24 September 2019. As directed by the government for verification of educational documents of all higher secondary cadre by special committee, all the principals of the higher secondary schools are directed to collect the mentioned documents of all the officers, principal to BGD and under their respective establishment and submit it hard copy or on before 10 October 2019. Lordship, based on this circular, Lordship, the present respondents as well as the writ petitioner submitted their necessary documents, including the base certificate. However, it was ascertained that there is some discrepancies with regard to base certificate possessed by the writ petition. Therefore, Lordship, come to my affidavit of respondent number 4 to 9.
Five to nine.
5 to 9. Page 22.
Yes.
This complaint was referred to yesterday also, Lordship. So I'm just referring to the affidavit.
Sorry, can I come to the page again?
Lordship?
Page
22.
Page 22.
Page 22 to 24, already referred yesterday. Therefore, Lordship, I'm referring to page 25 as a part of complaint.
Yes.
This is
Yes, carry on.
this is complaint affidavit under form number 3, Lordship. Form number 2. Paragraph 1, I'm reading paragraph 1 of the affidavit, Lordship, page 25. That I am the complainant in this case. Paragraph 2, Lordship. I have enclosed here to a complaint making allegation against, Lordship. Allegation against Shri Wai Vantongo.
Yes.
So my complaint involved allegation. And Lordship, kindly turn to page 26.
Yes.
This form number 1. attached to the complaint, Lordship. Paragraph 5, page 26, paragraph 5. May I read, Lordship? Names and address of the witness whom the complainant desired to examine in support of the allegation. So my complaint involves allegation, Lordship, not only grievance. And paragraph 6.
Yes. Yes, carry on.
Paragraph 6, I'm reading paragraph 6, Lordship.
Yes.
Particulars of the documents relied upon by the complainant in support of the allegation.
Yes.
What was the allegation, Lordship? Possessing of birth certificate where there are discrepancies. Which certificate was subsequently proved to be fact?
Yes.
Therefore, Lordship, based on a complaint involving allegation made by the private respondents, Lokayukta investigated the matter. Verification was sent to the concerned university, and the concerned university replied to the queries by the Lokayukta that the certificate possessed by the writ petitioner is not genuine. That finding decision was based on a complaint lodged by the present respondent 5 to 9. Therefore, Lordship, Lokayukta has jurisdiction to investigate the complaint involving allegation, Lordship.
Yes.
Lordship, may kindly come to page 29 of the writ petition.
Yes.
This is the birth certificate which was subsequently proved to be fact. Page 29 of the writ petition. This birth certificate was issued
29.
29 of the writ petition. Mr. Lordship got it?
Yes.
And come to page 52 of my affidavit.
No, what is page 29?
This is the birth certificate issued from the Kanbor, Lordship, from Kanbor University.
This is the false one.
Yes. This was issued in the year 2016.
Yes.
Page 52 of my affidavit, Lordship. This was proved not genuine. Page 52 of my affidavit, last page. Yes.
Yes.
Now, Lordship, the writ petitioner is possessing two birth certificates. One is already proof fact, not junior. Come to the second birth certificate, Lordship. Page 28.
Oh,
Writ petition.
yes.
Lordship, I'm reading second column after underline, Lordship, having, as Lordship Kadi, having passed the university examination held in the year 2011 with first division, is awarded the degree of Bachelor of Education petitioner to the writ petitioner. And the down below left, on the left-hand side, Lordship, this certificate was issued by the Registrar of the University on 4/3/2021. Come to statement at paragraph 18 of the writ petition.
Eighteen,
18 of the paragraph 18.
right,
Yes.
yes.
May I read, Lordship? That the petitioner beg to state that on 14/2/2022, the petitioner has submitted a reply to show cause notice dated 8/2/2022 by stating that he obtained the BEd degree from CSGM University, Kambor, that is the fact one, Lordship, for the sole purpose of enhancing his intellectual capacity and personal knowledge and not to gain any service-related benefit. The BEd degree from CSJM University, Kambor was submitted in the year 2018 and no benefit was derived out of the said act, Lordship. In other words, the petitioner is saying that the promotion to the post of principal and the senior principal has been done based on the certificate issued from Meghalaya, Shillong, Lordship, which was issued in the year 2021. However, promotion to the post of principal was in the year 2014 and 2017, Lordship, when he doesn't possess any base certificate, Lordship. And paragraph 21, Lordship. Page 11. May I read, Lordship?
1 minute. Yes.
Paragraph 31. May I read, Lordship?
Yes.
Page 11. That the petitioner beg to state that the service benefits of the petitioner was on the basis of the genuine paid degree certificate issued by the CGM University, Shillong, Meghalaya, and not on the basis of the paid certificate obtained from CGM University, Kanpur, Uttar Pradesh. Paid certificate was issued from Shillong in the year 2021. At that time, he is already promoted to both of principal and the senior principal. It can be clearly understood that last promotion of the petitioner was from the boss of principal to senior principal on 13/12/2017, Lordship, based on the fact certificate, and submitted the paid degree from CSGM University only on 10/10/2018, And as such, the petitioner has not availed any service benefits, but the respondent authorities by impure notification dated 24/3/2023 has revoked his promotion to the post of principal on 17/7/2014, despite the fact that his promotion was not on the basis of the bid degree from CSGM University Kampong. This clearly shows that the impure notification dated 24/3/2023 was issued under misconception that the petitioner has availed the promotion on the basis of the bid certificate for which the action of the respondent authorities is liable to be interfered with by this honorable court on the ground of arbitrariness and unreasonableness. Lordship, after availing benefits on the strength of the fact certificate, now the writ petitioner is coming before this court that Lokayukta has no jurisdiction and Lokayukta should not investigate the position of the fact certificate, Lordship. Lokayukta has jurisdiction. It's a complaint involving allegation.
Reason. You have also raised this before the department. That's what we are saying.
No, Lordship.
Department is initiating some proceedings for what?
That is
purpose?
based, that is after the registration of the Lokayukta case, Lordship.
The same issue.
Yes, same issue. Therefore, Lordship, my humble submission is the writ petitioner is not coming before this court with clean hand. From the statement itself, it reveals that
Yes.
therefore, Lordship, let the Lokayukta investigate the matter and allow the Lokayukta to come to a final decision with regard to position of the fact certificate, Lordship.
Yes.
And lastly, Lordship, with regard to the judgment of the BAS in the year 2013,
Yes.
the subject matter before this honorable court was with regard to determination of seniority, Lordship. This honorable court never directed the authorities to promote a petitioner in violation of the rules.
Which order?
Lordship, the order was referred yesterday also, Lordship.
4/9.
Yes, Lordship. It is reflected by affidavit page 16, Lordship.
Yes.
Because court order is reflected in the promotion order, Lordship. Page 16 of my affidavit, Lordship, first.
So it's available in page 45 of the writ petition.
Yes. By this order, Lordship, seniority of the writ petitioner was determined. No direction, nothing with regard to promotion. However, Lordship, may kindly see the promotion order, page 16
Page?
of my affidavit.
Page number?
16 of my affidavit. This document was referred yesterday as also, Lordship, page 16 of my affidavit. First, promotion order of the writ petitioner. Page 17, Lordship. Yes. Serial number 1 is the petitioner. And on the right-hand side, Lordship, promotion in compliance of the Honorable High Court, Kohima bench, in case number so and so, so and so, so and so. He could manage to get promotion in violation of the rules, Lordship, by misinterpreting the judgment passed by the Honorable Court. Because, Lordship, this Honorable Court never direct the respondent authorities to give promotion to the writ petitioner in violation of the rules. Because, Lordship, from BGT, the next promotional post is to the vice principal, not to the principal, Lordship. But the writ petitioner was promoted directly from postgraduate teachers to principal in violation of the rules.
Yes.
That too without possessing BEd degree, Lordship.
So we
Those are the facts. Those are the facts.
We are not going into this.
Yes, Lordship. I'm just projecting the facts.
These are available. We have already taken
Lordship.
photo.
Therefore, Lordship,
See whether the order of the Lokayukta
is
as per law or not?
So my humble submission, Lordship, Lokayukta has jurisdiction to investigate the complaint involving allegation,
Yes.
and this honorable court may allow the Lokayukta to proceed with investigation. So I conclude my submission.
Yes.
Much appreciated.
No reply, Justice.
I should not have, but yesterday's order, it clearly says that I have reserved the right for reply. So I have to comply with the order passed by this honorable court. Lord.
You have reserved. No, you are entitled to a reply. No doubt.
I cannot overcome the order passed by this honorable court, Lord.
You are most certainly entitled, but we want to know what is there to reply. Is there anything to reply? You have already narrated your facts. These are, in these circumstances, the Lokayukta was compelled to invoke its jurisdiction. That is what the respondents are trying to project.
Yes.
And these are the materials which go much beyond than
What Lokayukta is supposed to do.
No, than an ordinary personal grievance. They are trying to project that you have manipulated the system to such an extent and has relied on certain documents which are incorrect or false, that even the authority for some reasons are not willing to stop you. Therefore, they have approached.
One has the liberty to make submission as he likes. But ultimately, this honorable court has to decide. In the conclusion of my learned friend's submission, that petitioner has managed the promotion order, which I took it very seriously also.
He did not hear it.
But yes, I will not take much time, Lordship, maximum 15 minutes of
I have
reply.
not heard that. I don't recollect.
Better not, Lordship.
Yes.
Reply is essential because of the fact that the council representing the Lokayukta has done a lot of research so as to demolish his case. So I would like to make some clarification on that. First thing, my learned friend has referred to Section 9 and 10 of Nagaland Lokayukta Act 2017. And then with that, he has referred to the definition clause under Section 2, clause F and G. So I would like to refer to those definition clause first, because it has to be cleared what is meant by the definition of complaint and grievance. Has your lordship is having the booklet?
Yes. Yes.
It's in page
9.
2. No. Before coming to the section, definition clause, section 2, definition clause, clause 1, F and G, lordship. Has your lordship got it? Complaint, F. Complaint means a complaint made in such form as may be prescribed, alleging that a public servant has committed an offense punishable under the Prevention of Corruption Act 1988. Therefore, any complaint should be an offense punishable under Prevention of Corruption Act in discharge of his official duty. That is very important, Lord. Now the question is whether the allegation is an offense punishable under the Prevention of Corruption Act.
Yes.
That is one. Coming to G, the grievance. Grievance means a claim by a person that he suffered injustice or hardship as a consequence of maladministration. Therefore, going by the definition in clause G, the grievance should be as a consequence of maladministration. Therefore, the relevant issue is whether the grievance is a consequence of maladministration of the petitioner. He is just a teacher. And the offenses which are punishable under the PC Act, Lordship is well aware, whether there is abuse of official possession or power by the petitioner, so as to investigate by the Lokayukta, taking into consideration of the definition clause of complaint and grievance, whether it is in the discharge of any official duty of the petitioner. That is also important. Now, how to distinguish between a complaint involving a grievance and an allegation? To decide that, it will be relevant to refer to the complaint, what type of a complaint the petitioner, the private respondent has lodged, the complainant has lodged. Kindly come to page 22. My learned friend has also referred to, but I will directly hit in the target by referring to this page, a complaint.
22 of the
Affidavit of the private respondents, that is 5 to 9. This is the complaint that is in the first page. Now come to page 23, second paragraph. Has your lordship got it? The paragraph starts with we.
Yes.
We, the undersigned, on behalf of the aggrieved party. That means the complaint who has lodged is an aggrieved person. They are aggrieved. Next page, the last paragraph. I am just referring to the relevant portion only. Last paragraph. Has your lordship got it? Therefore, we, the undersigned, on behalf of the PGD and PEC recruits 2004 and 2008 batch, whose seniority has been superseded, request your esteemed authority for thorough investigation and examination of this matter so that his promotion will be reviewed. Very, very clear. Without applying any method, without applying any principle. Their own complaint says that it is a matter relating to seniority and grievance, and they want by promotion to be reversed. So the grievance is seniority. Based on this complaint, Lordship, the Lokayukta has taken up the investigation. Therefore, the nature of the complaint will decide whether there is a grievance or it is just an allegation. Now again, while referring to the submission, of course, I would have replied under submission of my learned friend for the private respondent, but then it will be equally relevant to refer while referring to the complaint, the form which my learned friend has just shown at page 26. Type copy is at page 28 of the same affidavit, Lordship. This is the type copy before the Lokayukta. This is the form of the complaint. And can they come to paragraph 4? Paragraph 4. If the complainant or the person for whom he is acting is aggrieved, the nature of grievance should be specifically mentioned. There is a clear stipulation in the rules how a complaint can be lodged. And the reason is given what? Effect in seniority. Therefore, the complaint is in a service matter involving a grievance about seniority.
Yes.
Therefore, the complaint is efficacy seniority and not about the fake certificate, as is mentioned in the form. Form is silent. In the similar nature, all other affidavits has been filed by all of them, the same format.
How does it change the nature of the investigation? Assuming that fake certificate is not made, not mentioned. Ultimately, assuming the fake certificate is taken into consideration, in the seniority will change. To that extent, the effect in seniority is the grievance.
It is a service matter then. If it is a service matter, Lokayukta will not have the jurisdiction.
Right. Is it your case that the fake certificate issue was never the basis of was never a part of the complaint?
Correct. But
it came out subsequently during the
yes,
investigation.
he tried to project in such a way that it track on along with this, so that only when these two matters are mixed up, the order which has been passed on 4th September 2013 by this Honorable Court can be overcome so as to demote me. The nature of complaint will decide. And in the complaint itself, in the form, they have mentioned that you specify what is the nature of the complaint. They said it is the seniority, efficacy seniority. So can the Lokayukta investigate about the service matter of a government servant in the service matter? Second schedule has part.
Let us assume the Lokayukta ought not to have gone. But having gone, it found out serious anomalies. Is the Lokayukta?
It is of no consequence so far as Lokayukta is concerned, because there is a forum. And when inquiry, there is forum for inquiry by other forum. Lokayukta do not have the jurisdiction. It is hit by Section 9, Clause 2 of the Nagaland Lokayukta Act. And in fact, the Department of School Education has issued the show cause notice on the same issue. So they are playing hot and cold. They don't know what they are doing. And it is the duty and function of the Lokayukta to check the corruption by the civil servants and the conduct of the civil servants in discharge of their official duty. Assuming that a certificate has been found to be a fake, which was inadvertently got, then is it in the discharge of his official duties so as to involve in some corruption? That is a conduct. So under the conduct, common servants conduct rule, he can be penalized. And in fact, that is what they have been done.
Yes.
Now, under citation, which has been relied upon by my learned friend, Mr. T.B. Jamir, representing the Lokayukta, a judgment has been passed by Mumbai High Court that grievance and allegation, when there is overlapping, then the Lokayukta will have the jurisdiction to investigate. That is the case he has referred to. My lord, that case is a case where there was abuse of power. In this case,
yes.
Therefore, when it is a case of abuse of power while discharging his official duty, when it is a case of abuse of possession, then definitely anybody can file a complaint and investigation can be done. But in our case, the situation is totally different. If it is a misuse of power or abuse of power by the person in office, then the same can be investigated. Anybody can file a complaint against that, and the investigation can be taken up. Now here, the reliance made in that case is not applicable at all so far as our case is concerned. What official power the petitioner has abused, what corruption the petitioner has committed in discharge of his official duty, so as to investigate that case issued by the Lokayukta. Therefore, Lordship, the facts are totally different with that case and our case, and therefore, the judgment is irrelevant. India is a large country. So many high courts, Supreme Court is there, and so many judgments are being delivered every day. All those cases cannot be just brought in and applied in a different facts and circumstances, Lordship. Therefore, the judgment which has been relied upon by my learned friend is irrelevant, taking into consideration of the facts and circumstances of our case. There is no abuse of official power by the petitioner. And that is a case where the official power has been misused.
Yes.
Now, Lordship, third,
Yes.
the referring to the ambient order at page 66 of the writ petition, the council has made the submission that the ambient order of 24th March 2023 is based in an order.
Yes, carry on.
The ambient order that is 24th March 2023, demoting the writ petitioner, has been passed by basing on an order of Lokayukta, which was passed on 28/2021, and that is not under challenge.
Sorry? Which order?
The last page in the writ petition, that is the order dated 24/3/2023.
Yes, that you have mentioned.
Yes. So this order is based in the order dated 28/2021, that is annexure O, page 41 of the writ petition. Ambient order is based on this order of the Lokayukta dated 28/2021. And the basic order has not been challenged. And the reference was made to a judgment that without challenging the basic order, challenging the consequential order cannot sustain. That submission was made. Here, Lordship, meaning thereby, he wants to say that the order of the Lokayukta is not under challenge. But looking at the cost title and looking at the prayer portion, Lordship will find clearly, prayer is at page 16, that we have challenged the entire proceeding of before the Lokayukta. Entire proceeding, not interim, not final, everything has been challenged. The whole proceeding has been challenged, and my submission and reply on this point is including the submission of the learned cabinet additional advocate generals.
Yes.
Prayer is at page 16. So entire proceeding has been challenged. Therefore, challenging the basic order, consequential order is misconceived. It is not necessary. Once the proceeding is challenged, everything will go. In a tree, there will be so many branches. But if the main stem is cut, then the entire tree will fall.
Yes.
Another very important thing, last one, on the submission of my learned friend, Mr. T.V. Jamir. We have taken the ground that, look, when there is a forum to agitate, to address the grievances, and when it is pending, Lokayukta will not have the jurisdiction under Section 9, Clause 2. There is forum. No submission has been made on that. So it is presumed that they are admitting that thing. And once that is admitted, then Lokayukta will not have the jurisdiction. going by the principle of law also, silence amounts to acceptance. So there is no submission, no pleading. It is totally silent on section 9, clause 2. Therefore, it is as good, it is admitted by the Lokayukta. Now, coming to the submission of the Learned Additional Advocate General, I would just like to narrate some sequence, because the Learned Additional Advocate General has made submission under certificates, additional challenge, promotion, all these things. P8 from the Shillong was obtained in 2011. That is page 28 of the writ petition. My learned friend has already referred to. Judgment in the writ petition was passed on 4/9/2013.
Yes.
Judgment is in WPC number 107K of 2012. That is passed on 4/9/2013. Page 45 of the writ petition as extract is shown. And the promotion of the petitioner to the post of principal is on 17/7/2014. That is page 26 of the writ petition.
Yes.
Thereafter, P8 was made compulsory in the school education department in 2016 for the PGTs.
You were promoted in
2014.
14.
Yes. And P8 was made compulsory in 2016. Government will be able to say better in that. The certificate in question, which has been questioned by both the government as well as by the private respondents, is of 22/11/2016, page 29 of the petition. And the learned counsel for the private respondents,
B8 is made compulsory in 2016.
Yes. After my promotion only. And the certificate which is in question by government and the private respondent.
In 2014, you were promoted to which post?
Principal. Page 26 of the writ petition, Lordship. Which according to my learned friend is managed. Who has issued the order? That is very important. Order, I don't pass the order of my promotion. It is the government who issues the order. Now, they are bringing an issue which has no relevance at all. That is paid. But accepting, they have not challenged the certificate. This was declared as not genuine and all these things. What consequences will be there? What benefit do I get from that certificate also? Even assuming. At best, your conduct is questionable. Okay, fine. You have issued a show cause notice. I have responded and arrive to a logical conclusion on that. So, they are playing hot and cold, Lordship. On one hand, they are saying that basing on the Lokayuktas, all these things they are saying. So, coming to the submission of my learned friend, Mr. Wati Chamir, who representing the respondent number 5 to 9. He has referred to page 30. And then in view of some discrepancies, the inquiry was initiated by the Lokayukta. So I have already referred to the copy of the complaint and the format issued by the Lokayukta and the format duly filled by the complainant has already been referred to. I believe that will cover up. It's a service matter involving the grievance of seniority issue, not any other thing. We have to go by record. Then, even assuming that, going by your saying, even if I have, even assuming that I challenge this, that this is genuine, this is not genuine, the certificate, before this honorable court, whether this honorable court can decide such a disputed question of facts. But therefore, this issue also make no sense. It is misconceived.
Yes.
And the date of issue has been referred to by referring to page 28 of the BH certificate. The date of issue is 4/3/2021. And that certificate has been obtained in 2011. Certificate is issued when I apply. So definitely the date of apply, when it is issued, that date will be entered. So
Where is the certificate again?
page 28. Did petition lordship. Although it is not important, but since it has been referred to, that is why I'm just trying to clarify this.
When
2011 examination, but the date of issue is 4/3/2021.
no, examination is one thing, and conferment of degree is another thing.
Yes.
When was the degree conferred?
Degree conferred in 2011, and the promotion is up 2014.
What basis are you saying your degree is on 2011?
Certificate itself says,
Where?
having passed the university examination held in the year 2011 with first division, is awarded the degree of Bachelor of Education. Only the issue of the certificate is 4/3/2021. And the left-hand side in the bottom, it is date of issue is mentioned.
Have you included your mark sheet or anything like that?
No. I have no instruction on that, Lordship. And since the department is conducting inquiry, let the department arrive to a logical conclusion on all this. If at all it is necessary. They are saying that my promotion is based on the certificate of this certificate. Certificate was, the promotion was in 2014. And the requirement of P8, the mandatory requirement started introduced only in 2016. So what they are saying and the sequence of events do not tally. Lokayukta can investigate when there is corruption cases. If it is misconduct or in connection with the conduct of this government servant, rules are there. Government servants conduct rules, and they have issued the show cause. Petitioner has replied.
Yes.
I have just when a lawyer asks the junior at the conclusion of the submission, had I left anything? But just the reverse, a doctor will say that, have I taken out anything? So I conclude with that, Lordship.
Lordship, me kindly allow 20 seconds. 20 seconds only. Just to, okay.
Reply to a reply.
No, not reply.
Your Lordship, yesterday the additional advocate is already.
One
Yes, sir.
minute. Yes.
Your Lordship, I'm just making one clarification, Your Lordship, with regard to prerequisite of B.Ed degree, Your Lordship. In our counter affidavit, Your Lordship, filed on behalf of the state respondents, Your Lordship, in page number 3, Your Lordship.
Yes.
I would just like to read this paragraph 5, Your Lordship, clarifying on the matter whether B.Ed degree was prerequisite from the year 2016. It's a wrong submission, Your Lordship. I would like to read from paragraph 5, Your Lordship. Just a clarification on this aspect, Your Lordship.
Let us find out your
Yes,
findings
Your
first.
Lordship, it was filed on 21/2/2024.
21.
2024.
Yeah. Yes.
Your Lordship,
Yes.
from paragraph 5, Your Lordship, if I may be allowed to read, Your Lordship. That, Your Lordship, had got it?
Yes.
That with regard to the statement made in paragraph 7 of the writ petition, the deponent states that the department, in compliance with the Honorable High Court's order dated such and such, passed such and such, reviewed the seniority of the petitioner. Accordingly, his seniority as postgraduate teacher from the date of deputation to School Education Department with effect from such and such was maintained. The court's order dated such and such was fixation of his seniority and not for promotion. Your Lordship, this is important. Schedule 3 of the Nagaland School Education Service Rule 2002 prescribed that the post of principal shall be filled up by promotion on recommendation of the committee. Selection shall be done from among the confirmed vice principals, provided he has completed a qualifying service of 12 years in the higher secondary schools and served as vice principal for 5 years. The post of vice principal shall be filled up by promotion on recommendation of the committee. Selection shall be done from among the confirmed postgraduate teachers, provided she has completed qualifying service of 12 years in the higher secondary as subject teacher and with B.Ed, Your Lordship. The petitioner was not serving as vice principal, the feeder post, at the time of his officiating promotion.
That's matter of inquiry which you are conducting.
Yes, I'm just clarifying that the learned counsel has said that the prerequisite of B.Ed degree was from the year with effect from 2016, but that is not the case. It was prerequisite from the year 2002 itself, Your Lordship, before his promotion, Your Lordship, as per the service rule. That's the only clarification.
Where is the service rule?
Your Lordship.
Your Lordship.
This one?
Yes, Lordship.
Where does it say?
Schedule 3, Your Lordship.
Schedule
3, Your Lordship.
Schedule 3, yes. Vice principal.
Yes, Your Lordship, vice principal.
No, this is which year?
2002, Your Lordship.
2002.
Under eligibility and other conditions for promotions, Your Lordship.
Where is the parent rule? Parent, where is the rule?
This is the rule, Your Lordship. In the rule, this is in the schedule, Your Lordship. Your Lordship, unfortunately, I don't have that. And we have also not annexed in the counter also, Your Lordship. The rule is not mentioned in the affidavit also.
You get a copy of your rules and tell us. Where is the scope? Where is the provision for promotion?
Page 15, Lordship. Lordship.
Page
15 of the rules.
15?
Yes.
I know this is the schedule. The schedule must be in reference to a particular rule.
Yes, Lord.
Mode of recruitment, rule 6, by promotion in accordance with rule 7 and 8. Okay.
I saw be it somewhere.
Okay.
In the schedule, it's also
Your Lordship, page 4,
7B.
Yes.
page 4, 7B.
Yes, yes.
Your Lordship, this is the only clarification I'm making.
Seconds.
Yes.
Lordship, 10 second, Lordship. Page 25 of my affidavit, Lordship. Page 28. There is a new council overlook this one, Lordship.
Yes.
Page 28.
28.
This is a form of complaint, Lordship, my complaint.
Hmm.
There is a new council referred to paragraph 4.
Yes.
I'm reading from paragraph 4. If the complainant or the person to whom he is acting is aggrieved, the nature of the grievances should be specifically mentioned. Effect and seniority, that is the grievance, Lordship. And come to paragraph 6.
Yes.
Particulars of the documents relied upon by the complainant in support of the allegation. Number 1, Lordship. First, appointment order from the parent department, deputation order. Number 2, important, Lordship. Bid admit card, mark sheet, and certificate. So that was the allegation with regard to bid certificate and the admit card, Lordship. Not only on seniority. Therefore, complaint involves grievance as well as allegation, Lordship. Much obliged.
These are your allegations.
Yes, Lord. Much obliged.
You will still have 10 seconds more.
Whether Lokayukta can enter into all these service
Any more
disputes.
replies?
No reply.
No,
Lordship.
right.
We are very grateful for Lordship's patient hearing. All of us will feel as if we own the case because we get satisfaction by making
Court gets
Is there-
satisfaction if the lawyers come prepared and argue. What ultimately is the judgment even the court at the date of hearing is unaware. All right, had learned counsels for the parties. Hearing is concluded, judgment reserved. Okay. In case we are unable to deliver the judgment here, then of course we'll have to take it back
Lordship.
and then decide.
Lordship.
Yes.
May it please your lordship.
The income tax, yes. Yes.
Item number 2, lordship.
No, we still have one matter.
For orders, item number 1.
Lordship, I have the instruction. My lord, the documents has to be filed through portal online, my lord. And this is perfectly working, my lord, as per my instruction, my lord.
Then you file it.
Yes, Lordship.
Is there an interim order here?
Yes,
Yes,
Lord.
yes, there is.
We will extend the interim order for 2 weeks.
For how many?
For 2 weeks.
For 2 days?
2 weeks.
Or 2 weeks, Lordship.
And you file it?
That is fine, Lordship.
And the The department will pass necessary orders in that matter,
Yes, Lordship.
right?
Lordship, my lord,
Heard, disposed. We'll pass orders.
Yes, Lordship.
deeply obliged, my lord.
For hearing item number 2.
May it please your lordship.
Yes.
So the government advocate was supposed to bring the records.
Lordship,
Have you got?
Lordship, this is the instruct. What I have annexed in my affidavit in opposition, Lordship. And this is the original copy, Lordship.
No, but it doesn't reflect why, what approval is sought for.
Lordship, Lordship, in fact, I have been informed that the matter has not been routed to the government, Lordship.
Then,
Lordship. So I leave it to your Lordship. That is the only instruction that I received.
heard, learned counsel for the petitioner, who appears through VC. Mr. B. Zimomi, learned counsel appearing for the state of Nagaland, government advocate. This writ petition is directed against the cancellation of the permit earlier issue to the petitioner to set up 5 numbers of unipole measuring 20 into 10 feet along NH 29 at Chumukadima town jurisdiction. Stop. Learned counsel for the petitioner submits that the petitioner is in the business of erection of unipoles and being desirous of undertaking such activities, he filed necessary application before the administrator, Chumukadima Town Council. Stop. He submits that at the relevant point in time, there was no, what do you call the committee? The town council.
Elected body, town committee, lordship.
Elected body in the town council. And the affairs were looked after by the deputy commissioner who was acting as the administrator of Chumukadima Town Council. Stop. On the basis of the applications made by the petitioner containing the particulars of the unipole proposed to be erected, a permit was granted on 4th of November 2022. By the ADC, come administrative, not the DC, ADC. Come administrator, Chumukadima Town Council. So, in terms of the said permit, the permit was issued specifying certain conditions, specifying certain terms and conditions under which this permit was stated to be effective from the date of issue of the permit. Stop. The permit was issued for a period of 5 years from the date of the issue. Stop. Subsequently, the petitioner also deposited how much did he deposit? 1 lakh.
1 lakh.
1 lakh.
1 lakh as permit fees for erection of the 5 unipoles. So while the petitioner was taking steps to execute the work, he was surprised to be served with a copy of the order dated, a copy of the communication dated 19 December 2022, whereby the ADC cum administrator Chumukadima town council cancel his permits due to lack of approval from the concerned department. So. Where? Learned counsel for the petitioner submits that on a plain reading of the cancellation order, it appears that this permit was cancelled not because of the violation of the conditions prescribed in the permit which was earlier granted to him by the order dated 4th of November 2020, but on the ground that there was a lack of approval from the concerned department. So it is submitted that in the permit granted to him, there was no reference that it will be subject to such approval as may be granted, as may be required from the concerned department. Stop. He further submits that while the petitioner was permitted to proceed with his work and his permit fees was also accepted, this cancellation order without issuance of notice is violation of the basic human rules of natural justice. Stop. In support of his contentions, the learned counsel has referred to the judgment of the apex court rendered in, what are the names? 2003, what was this? What was the party's name in 2003?
Lordship.
What was the name of the party in the judgment he referred in 2003? SCC.
2003 is Lordship.
And so versus so and so.
2001 Lordship. Kumar Mandal Lordship.
Reported in 2001, 1 SCC 182.
Yes, Lordship. Kumar Mandal Vikas Nigam Limited versus Girja Shankar Pant and others.
As well as the judgment of the apex court referred to in rendered in so and so versus so and so, reported in 2003 4 SCC 557 para 19. Learned counsel for the petitioner submits that the petitioner ought to have been put to notice and he ought to have been given an opportunity of being heard before the unilateral cancellation of the permit order was issued. So, being agreed, the present writ petition has been filed. The learned government advocate submits that as per instructions received, cancellation was made on the basis of the lack of approval from the concerned department. So, on on 8/11/2024, when the matter was called up, upon hearing the counsels at some length, the court permitted the government advocate to complete his instructions and call for the relevant papers to apprise the court as to the grounds for cancellation without issuance of notice to the petitioner. So, the matter was fixed today. Today, when the matter is called up, the learned government advocate has placed before the court the original communications relating to the application put up by the petitioner, the grant of permit issued by the ADC and administrator dated 4th of November 2022, as well as the cancellation of permit dated 19 December 2022. Stop. He submits that there is no further instructions received. Stop. He also fairly submits that no instructions is received in respect of whether any approval is necessary from the concerned department. So, the counsel for the parties have been heard. Meetings have been carefully perused. The judgment cited have been carefully noted. The respondent authority is the Dimapur Municipal Town Council. Chumukudiman Town Council. They are governed by, where is the act? Town Councils Act. They are governed by the Nagaland Municipal Act 2001. So, at the relevant point in time, when the permit was issued and the cancelled, there was no elected body of the municipal council, and accordingly, the administrator who was appointed had taken over the day-to-day conduct of day-to-day business of the town council. So, constitution of the municipal council is prescribed under Section 8. Section 9 of the Act prescribes for composition of municipal council. So, Section 10 provides for duration of the municipal council, which is for 5 years from the date appointed for its first meeting. Stop.
Lordship, Section 20, Lordship.
Section 20 provides for constitution of the town council. Section 21 provides for constitution, a composition of the town council. Stop. Where is the administrator?
Section 83, Lordship.
83.
Yes, Lordship. '82 speaks about court order stay by court, and 83 in any other situation, Lordship, if the election is not held.
Where the term of the town council expires under the prescription of the Act, and where elections cannot be held, then under Section 83, the government may by notification appoint a government officer to be known as administrator to exercise, perform and discharge power, duties and functions of the municipality, subject to such directions as may be given on this behalf by the government. Better. From the perusal of the above sections reveal that after the expiry of the term of the municipal town council, when an administrator is appointed, then the administrator will exercise, perform and discharge the powers, duties and functions of the municipality subject to such directions as may be granted by the government. Stop. As such, the functions and the powers exercised by the administrator at the point in time when elected members of the town council were not in office. Such powers and functions will have to be accepted to be powers issued by under the town, powers by the town council under the provisions of the statute. So it is informed of the bar that as on date, elected body is duly constituted and are members of the town council. So coming to the question of whether natural justice is to be is required, the yardstick of natural justice is to be applied to administrative orders. The apex court in Oryx Fisheries versus so and so reported in 2010-13 SCC 427, referring to the earlier precedents, have clearly held that natural justice is ingrained in all orders, not just judicial or quasi-judicial, but including administrative orders. Stop. All administrative orders must necessarily follow the parameters to satisfy requirement of compliance of the principles of natural justice. Stop. In so-and-so versus so-and-so reported in 2003-4 SCC 557, it is clearly held by the apex court that natural justice is inherent even in an administrative action. Stop. Para. Taking note of the law laid down by the apex court, it is evident from the papers placed before the court today by the government advocate that no notice was issued to the petitioner prior to cancellation. And the ground for cancellation was, as reflected in the order, is because of lack of admission from the concerned department. So the provisions of the Municipal Act in respect of the functions of the town council do not reflect any specific need for approval or any other authority. Stop. However, in the course of execution of business by the state, if there is any circular or notification which specifies that all actions are required to be approved by any concerned department in the state, all actions of town council will be required to be approved by any concerned department of the state, then no fault, etc., can be attributed to such a decision taken by the state. Stop. However, in the facts of this case, no such office memorandum or notification has been placed before the court. The permit which was issued was made subject to the following condition: 1, 2, 3, 4, 5. However, the cancellation order does not reflect that the permit was cancelled because of any or all of the conditions prescribed in the permit. Stop. The only ground for cancellation is with regard to the non-approval of the concerned department. So what approval is required to be sought for has to be specified by the authority in the cancellation order, or at least in the connected or in the office records. So no such documents have been placed before the court today. Under such circumstances, taking note of the law laid down by the apex court, it must be held that all administrative actions inherently require compliance of the principles, basic principles of natural justice. So, since the cancellation, as discussed, since the cancellation of the permit is not in respect of, not on the ground of violation of the conditions mentioned in the permit, the petitioner strike it out. Prior to cancellation, it was incumbent on the respondents to issue a notice to the petitioner, informing of their decision, informing of their intention to cancel the permit and the grounds for such cancellation. Stop. Such notice was required to be served on the petitioner, more particularly when the cancellation is not based on, for the reason, not based for the reason for violation of any of the conditions prescribed in the permit. Stop. This court therefore comes to a conclusion that the impugned order of cancellation of permit is contrary, is contrary to the principles of natural justice and therefore cannot be allowed to be sustained. Stop. The impugned order of cancellation therefore stands set aside. The matter is remanded back to the town council, Chumukudima town council, who will redecide the matter after issuance of proper notice on the petitioner. Stop. The petitioner will be given an opportunity of being heard, and thereafter, if the authorities consider it necessary to cancel the permit, appropriate orders accordingly may be passed.
Lordship.
Writ petition accordingly allowed in terms of the above.
Lordship.
Disposed.
Documents.
Yes, the original documents placed before the court are handed over back to the learned government advocate.
Highly
Highly obliged.
Yes.
For hearing, item number 3.
My pleasure, Lordship. Lordship, in pursuing the court order dated 11/11/24, I was directed to place before the court the minutes of the meeting of the Mogadishu Municipal Council held on 11/6/2019, Lordship. Lordship, I will be allowed to place this on record.
Yes. Yes. But there is no selection process,
Lordship, I think that.
no selection.
If I may, however, this document does make it clear that the quota as claimed by the petition has been exhausted.
No, that's okay, but how can you also belong to the same clan?
Lordship, for that matter, my point is not on land ownership basis.
On what basis? These minutes do not say anything. On what basis are you appointed?
I have applied and yours point on it. So far as my view is concerned.
No, how have we applied? There's nothing in the minutes. Do you have a copy of the minutes?
Yes.
So, very clear. Public appointments should be made by proper notifications unless there is an exemption.
Lordship. However, the Supreme Court in West Bengal versus Tiwari has been clear that when delay is there and when there is a third party right that is created, ordinarily the jurisdiction ought not to be exercised, my lord.
No, that's quite all right. When was the appointment made?
19.
19.
Yes.
Why have you come so late?
Your Lordship, I have explained, even in my representations, I have made several representations and then I was
But
out of
your-
station.
Your claim is land ownership.
My claim is also land ownership as well as two grounds, Your Lordship. It is to be considered first on land ownership basis, if at all it is found that I am not eligible for land ownership consideration, then in that case, the post has to be advertised. And I should also be given the opportunity to compete. Even the government notification, Your Lordship, government notification also clearly lays down so. And in the event it is not land owner
Where is the
candidate,
government notification?
page 19, Your Lordship.
Where does it say?
3C, Your Lordship. 3C. The last paragraph. That last line is.
We'll have to interfere with your appointment. Unless you show how the appointment is made.
Lordship, at the cost of repetition, petitioner has deliberately refrained from sharing the material, the information that the land ownership quota has been exhausted, and I have made specific averment in my affidavit. And there is no counter to that. Therefore, Lordship, it is deemed to be admitted. And when one is before honorable court with unclean hands, with suppression of material facts, then the merits of the case cannot be gone into, Lordship. And the alternate prayer also it is an offshoot of this petition only, my lord. Perhaps on technicalities, my lord will consider.
Well, I think it's better you take it up before the next bench available. Because you'll have to go deep into and satisfy us.
Your Lordship, my representations are there. I was never, despite my,
Not your
yes,
representations, he has
Yes.
raised certain objections. Number one is a delay.
Your
Number
Lordship.
two is the fact that there is an element of suppression of facts.
No, Your Lordship, there is no suppression of fact. I have clearly stated in my, because whatever was made available to me, on the basis of it, it was, on the basis of that only, I have, I had to approach this honorable court. Your Lordship will see the application itself, Your Lordship. This was the basis. This was the application, and they have never replied to my submission representations that it was not on the basis of land ownership right that it was considered, Your Lordship. Only now,
You have filed your affidavit.
at this stage, yes. At this stage, they have come up with this stand, Your Lordship. Even this meeting resolution was never made available to me, Your Lordship. Only now I'm coming across this. Only when this honorable court has asked them to produce a record, they have produced it. This is the position. And in that case, Your Lordship, I will also reply to the allegations made out. The stand taken by the respondents. I'll file my affidavit in reply. Otherwise, yes, I'll file affidavit in reply in that case.
Because you'll have to answer these.
Yes, Your Lordship, I'll answer it.
Third learned councils of the parties. Pursuant to the today's 13th. Pursuant to the order passed on 11/11/2024, directing the council appearing for the municipal council to place the relevant records, more particularly the minutes of the meeting of the Mokokchung Municipal Council held on 11/6/2019. A copy of the minutes dated 11 July, held at 11 AM, is placed before the court. These minutes revealed that the claim for appointment of park chowkidar through the landowner's quota cannot be proceeded with, as the landowners, as the same was appointed earlier, as resolved in resolution number 2 of an earlier meeting held on 12th of June 2014. So the minutes further reveal that in order to avoid inconvenience, the meeting unanimously resolved to appoint the respondent number
Five. Your Honor.
5,
Yes.
in the interest of public service to be post vacant created due to the expiry of the earlier incumbent, and not as landowners appointee. Stop. Whereas, in view of these, in view of the minutes being placed before the court, it is evident that the petitioner perhaps may not be able to seek a direction to consider his case for being appointed in the landowner's quota. But what is also noticed is that the private respondent appears to have been appointed in public interest to the post, appears to have been appointed in the post only in public interest. However, without following the proper procedure, namely to advertisement or selection, etc. Stop. The counsel for the private respondent further raises questions and claim of the petitioner on the ground that he had approached his court after considerable delay, and when third-party rights have already been established. And further, that the landowner did not come with clean hands. The petitioner did not come with clean hands, as he did not reveal in the writ petition before this court, that one of his clan members
Yes.
was earlier appointed in the landowner's quota, and therefore his claim under landowner's quota is not available. So, in view of the objections raised by the counsel for the private respondent, the counsel for the petitioner craves leave to file affidavit in opposition. Reply.
Yes,
He prays for 3 weeks.
3 weeks, your lordship.
3 weeks time. Let the matter be listed again after 3 weeks. Copy of the minutes placed by the council is kept on the case record.
Pleasure, your lordship.
Yes.